So, Your Honor, may I
Sure, jump in,
jump
because
in?
we're just trying to
The
get
water
to...
seems warm, so I figured this is the time
Feel
to
free,
do it.
it's a jacuzzi, go ahead.
Your Honor.
We're on the record in case number 831543, Hunwardsen versus Finity Lifestyles, DBA Real Water, and ETT1, DBA Terrible Herbst, pages 3 through 34. Counsels for plaintiffs, would you like to make your appearances, please?
Of course, Your Honor. Good afternoon, Your Honor. Teddy Parker and Eric Pepperman on behalf of the plaintiffs.
Good afternoon, Your Honor. Joul, Odou, and Eric Freeman on behalf of Infinity, Lifestyles.com Inc., Real Water Inc.
Good afternoon, Your Honor. Valerie Rojas and Jan Tomasic on behalf of defendant Terrible Herbst.
Okay. Thank you so very much. Okay, so by agreement, we're going to start first with Michael Bush. Michael Bush is on the jump drive that the court received on December 26th. And I'm just going to read from the cover letter, make sure everyone's on the same page. And if you all have a difference of opinion, we can find it out sooner rather than later. Okay, so what the letter says is, based on the summary judgment ruling last week, plaintiffs revised the deposition designations for Michael Bush. As a result of the revisions, Terrible Herbst's objections to the following pages lines are moot. 164, 20, 20, 25, 165, 1 through 25, 166, 1 through 3, 182, 18 to 24, 183, 2 through 25, and 184, 1 through 5. And it says, enclosed, please find a jump drive and claim the redlined transcript and chart of objections relating to Michael Bush. So does everyone agree that that's the scope we're looking at, that 1226 drive that takes into account plaintiffs' redesignations and the changes there too?
Real Water agrees, Your Honor.
Yes, Your Honor, that's correct.
On behalf of plaintiffs?
On behalf of plaintiffs.
Thank you.
Terrible Herbst agrees.
Okay. So I'm going to do then counsels. Seems to me the first, I was really going to go to the objection chart because I don't know if you're doing it the same way. Basically, what I popped up on my screen is I've got the two screens, right? So I've got the transcript screen and the objection screen. So I was going first to the objection screen, then transfer over to the transcript screen, and then we can address the objections. Does that work for everyone?
Yes, Your Honor.
Yes, yes. And,
Yes, Your Honor.
okay, perfect. The first one I see is the designation 47, 2 through 25. Terribles has an objection, relevance form, foundation, speculation, leading, vague, and misstates testimony. I do not see that there's any objection for any designations prior to 47, so is it correct that the court should view that whatever designations were made prior to page 47 are coming in?
Real Water agrees, Your Honor. And for the record, Real Water doesn't have any objections to Michael Bush's testimony that we'll be talking about at this juncture.
I appreciate it. I was going to ask you that because I only saw plaintiffs and terribles, and I see a highlighted for terribles, which I haven't yet gotten to, and I'll ask about that one when we get there. But I think that's a change, and we're just going to make sure. Counsel for plaintiffs. On, I'm only looking at your objection pages because I presume you all have correctly stated on your objection pages the pages that the court needs to resolve, and I don't have to start with page 1 on each and every one of these depot designations. If that's not a correct, based on the jump drives and based on prior conversations in court, that's my understanding. If that's not correct, somebody needs to let me know.
That is absolutely correct, Your Honor.
I heard Real Water, you agree? Terrible Herbst?
Yes.
Okay.
Yes, Your Honor.
Okay, so now we're going to, the court's inclination on taking the totality of 4701 to 4725 and the objections raised there too is to overrule the objections other than line, court has a question starting at line 4722 because it looks like it's a partial question with a partial answer, and that one would fall within relevance and other things, because the end answer ends up, thank you, Shane, for putting that up. If any chance you can make those bigger so everyone can see them? Yeah, there you go. You see 4722, and other than Nestle milk plant, had you ever worked on a food or water plant line other before coming to Real Water? Question mark. Oh, I'm trying to think. No, I don't. No, I don't isn't really a response to have you ever worked. So it's unclear if that was a partial answer or what that was intended to be, since I don't have the.
Your Honor, I believe the answer continues on to 4801.
Okay, but is that objected to? I mean, okay, let me make sure I've got this correct. In the transcript portion, okay, based on you all's key, I've got the. Let's go. Wait, hold on. So this one, underlined in blue. You say it says they're underlined in red. The objections of terribles, but there's no red underline. This is all, at least from this jump drive, it pops up orange.
Oh, Your Honor, I can explain this. So,
So you can understand why I'm
yes.
looking at. I looked at my multiple pages of clues and keys. So please enlighten to me what's missing on my Monopoly board, please.
Yes. So, and I do apologize. It is
Okay.
a little confusing on this because the different parties serve designations, and so the cuts included all the parties' designations in different colors. So what you're looking at is Real Water's separate designation, and they only designated through 4725. But if you look in the blue underneath it,
Green?
it's
Is
the
that
same
blue?
designation, 4702, and it continues on through 4815.
Okay, I saw that as green, and I didn't see it cross-referenced with my chart. Okay, so let's go back a step. But the only objection is terribles, both on 47 and 48. So why is there a double designation? Or is the answer, I only look at the underlined sections and ignore if it doesn't have an underline?
Well, Your Honor, this is a confusing example because Real Water designated the same portion of testimony for Mr. Bush as plaintiffs did, but Terrible Herbst only objected to plaintiff's designation of the testimony. It did not object to Real Water's designation of the same exact testimony.
That's not on my objection chart.
On the objection chart is Terrible's objection to plaintiff's designation.
Okay, right. But counsel, here's the challenge. Are you telling me that there's somewhere else that says there is a Real Waters designation and that Terribles does not object to it? Because I thought when looking at this and when I was trying to prep for this, I looked at the objection chart. That's why I asked a few moments ago, right? Look at the objection chart, go to only the ones that have the objections, and then go to the depot. So how would this court know? I appreciate what you're saying, but how would the court know that based on what's been provided to the court? Guess you gotta start using this lovely crystal ball that doesn't really, it's pretty, but doesn't, enlighten me.
Well, Your Honor, I think that is a question for Terrible Herbst because on this specific deposition, when we met and conferred for a lengthy amount of time on last Thursday, Terrible Herbst objected to plaintiff's designation of 4702 through 4815. Then with respect to Real Water's designation, Terrible Herbst did not object to any other designations. I brought it up and said,
I'm hearing what you're saying. The reason why I'm stopping you for a quick moment is, my question really is, what resource material have you all provided the court that would give the court the outline to know this? Because the objections, when I was right, the objections don't say it's only as to one party versus another party. Remember, court was only going to resolve if there's objection. So do I need to pause each time and say, is this an objection as to one party and not the other party? That's going to really...
There's not many of these. There are multiple. The way that we tried to indicate that was by including the designated testimony by Real Water here, which is in the deposition cut in orange. That's all designations by Real Water. And then plaintiffs in blue. And some of it is the same. But Terrible Herbst's objection is underlined to plaintiffs, but they have no objection to Real Waters.
And the court's clue to that would be listed on which letter of communication to provide the court that background.
Indicated in the deposition cut that the red underline is the testimony objected to by Chairman Herbst.
But you understand there's the same exact testimony, which has a cross out in part, not an underline, but a cross out in the orange. Then there's nothing else in the orange. Okay. Counsels, it is what it is. I'm trying to find the most efficient way to get through it for you all. So realistically, and I'm going to let Counselor Terrible Herbst speak. One idea is if I see an objection, I treat that as an objection to no matter who designated, and I ruled on it because it really doesn't matter. If I've got a waivers to one and an objection to the other, you all are not between now and the time of trial that one person's going to withdraw it, the other person's going to say, I really want it in and have to come back before the court to really re-argue that. Are you? Because I'm available January 2nd. I don't think anyone wants to be here or New Year's Eve day. I mean, come on, folks. Online is. So isn't the best way to do it just say, look, if there's an objection, Terrible Herbst at least objected to somebody's, or Real Waters objected to somebody's, or plaintiffs objected to somebody's, and I treat it as an objection as to all, regardless if they, since you all have not told this court, look, this is to both versus one, wouldn't that be a more efficient and more feasible way to address these?
Your Honor, if I may,
Sure.
First of all, yes, I agree that would be a more efficient way. And I would disagree that our designations or our objections to plaintiffs apply to Real Water. I think you can look.
They do or do not?
Do not. The reason is.
I mean, they do? I'm sorry. Just do your objections to plaintiff's testimony equally apply if Real Water designated the same testimony?
No, Your Honor, because the background information that Real Water has used from this testimony is fine from Charitable Herbst's perspective. It's once the plaintiffs start getting into the questions and answers about the Nestle milk evaporation plant, that's when it gets too far. So we have no problem with Real Water's designation of Mr. Bush's background information only, including the fact that he worked at Nestle. But as you see, the plaintiff's questions start getting into the audits and the food safety program at the Nestle plant, which relates to dairy products, not water.
But that's 48, not 47, isn't it?
Yes, that goes on. So I think you can look at just the underlines because those are the applicable objections.
That's kind of a little different than what the court said. Okay. Realistically, there's got to be some way to walk through these without having to say, is this one for both? Is this one partially for one, partially for the other? Do I have to read 3 different versions of it, right? It's supposed to be, if there's an objection, the court addresses it, because you can appreciate there's underlining to both the 47, I'm just going to make it simple, and the 48. But I'm hearing Terrible Herbst say 47 is not really objectionable, but it is objectionable, and 48 is because plaintiffs designated 47 and 48, and 48 is really the objection, but you can tell from the court what's been presented to the court has been presented as 2 separate sections with different objections, if I look at your objection charts. So realistically, since I'm going to have to address all objections,
Your Honor, you're making perfect sense to me. I completely agree with you.
Amazingly, that happens sometimes, doesn't it? Until you disagree, and then I'm not holding you to it, but go ahead.
No, even when I disagree with you, I do find you make a lot of sense, to be honest.
No worries, go ahead. Nature of the job, go ahead.
The problem here is that Terrible Herbst is not objecting to testimony because it's objectionable. They're objecting to it because plaintiffs designated it. And then when Real Water designated the exact same testimony, they're not objecting to it. So
I'm hearing what you're saying, counsel, but realistically, if we do this for each and every designation for each and every person, okay, I won't just be seeing you today. I can't see you tomorrow. I'm in trial tomorrow, okay? But you'll be spending so much time here. But then you're going to have a record that's going to say, ruled on this objection is to one party, this objection is to another party. Does anyone really want a record like that? Or don't you want the court either it's in or it's out, right? It doesn't, if you walk through this time of trial as a live person, right? It doesn't matter if I got 3 hands where 3 people jumping up and saying they object, right? Or I got 2. Now it may, on the scope of the object, and this is not anything do not use this against me in any other case, but you know what I mean? There may be an issue where one person may call it hearsay, and it may be binding of a party opponent for another. Okay, that's my easy example for the morning, right? Or afternoon, still it's afternoon. I was in here all morning. Sorry, it doesn't matter. That being said, I have to rule on the objection. So if you all wish me to stop each and every objection and ask, is this entirety objected to as to one party, only a partial party? You understand how cumbersome that will be, and does it get you any net result for anybody's purposes, because it's either in or it's out, unless there is a unique circumstance, which so far we're only the first one. I mean, if there's an attorney-client issue, right? If there's a binding on an agent issue, I'm sure you all bring this up, but for these general relevance, the more, shall we say, generalized objections that aren't party-specific, do you all want me to stop and ask each and every time? Because there's no instructions to this court that gives me any of this heads up, right? And do you want to say, well, do you want two sets of analysis? One is, well, why do they object to one party but not the other party? And we go through this each time, and then Real Water says, I have no position. We did it, they didn't, you know what I mean?
So, Your Honor, may I?
Sure, jump in,
Jump
because
in?
we're just trying to
The
get
water
to.
seems warm, so I figured this is the time
Feel
to do
free,
it.
it's a jacuzzi, go ahead.
Your Honor, in terms of this Bush depot designation, like Mr. Odou said, there are no objections from Real Water, only Terrible's objections. So this one should be pretty easy. You're only considering Terrible Herbst's objections. There's one from the plaintiff on 84.
In 84.
But other than that, it's all Terribles. I'm sorry, there's two on plaintiffs, 138 and 150, and then that's it. So this one may be one that we go through pretty quickly, because there's only Terribles and plaintiff. Real Water's not.
I'm hearing what you're saying, Mr. Park. The reason why I'm stopping you is Mr. Pepperman's statements were a little bit different, right? Is that
They were.
Terrible objected from his position, which in part is going to be accurate, what I'm hearing from Terrible, in part maybe not accurate, but Terrible's only objected to plaintiffs for some cases, plaintiffs and Real Water in other cases, or if plaintiffs designated more than Real Water did that may overlap pages, it may not be accurate, consistent with how it's reflected on the objection chart.
Right.
So realistically, I was going to go through the objection. I thought you all said at the beginning, look at the objection chart. Go to each one of these designations. Make a ruling, Judge, on each and every one of these. It doesn't matter if it's objected to on behalf of both or one, because it's an objection.
Exactly.
But now I'm hearing that.
No, I think Mr. Pepperman was getting into more of a substantive issue that may carry over and bleed into almost all of these deposition designations. We do believe that ETT has objected to things that the plaintiff has suggested only because we suggested it. But that's a substantive inquiry you'll make at the time we go through each one of these.
But does it matter, Mr. Parker?
It shouldn't.
Honestly,
It should
because
not.
realistically, I have to look at the legal basis of each of the
That's right.
objections. I can't get in. Like I said, I've got this beautiful. I keep getting to use my brand new beautiful crystal ball,
That's right.
Which my extern got me as a very nice gift. But it doesn't tell me what any of you all are thinking. Okay, I'm not going to pretend it does. So realistically, what may be in people's minds, that's nice.
That's right.
You know what I mean? Whether it's true or not true, that's nice. I have to focus on the law
That's right.
and the rules and the statutes and the codes, right? And so I just have to say, does this merit exclusion, inclusion, or part?
That's right, Your Honor. We believe that's why we're here today. Mr. Pepperman was making more of a substantive remark as opposed to a procedural one. I think procedurally, you rule on the objections regardless of the number of people joining in it based upon the law and the rules.
And if somebody thinks for a particular one I have to do something different, then please let me know when I get to that section, right? Does that make it clean and clear for everybody?
Yes, Your Honor.
Yes, Your Honor.
Does anyone disagree with that concept? I mean, as long as you get your objections heard, do you?
Right. No, we have no issue with who's ruling, who's objecting and what the ruling is. As long as we just get a ruling on the objections, I think that's
Okay.
going to be most efficient.
Exactly.
Real Water, even though this does not apply to you,
Well, it
because
does-
you're not Bush, to the extent it may apply to you and others, but it does indirectly apply to you because you made some designations in Bush which may be impacted. So would you like to be heard? If you don't, it's perfectly fine too.
Thank you, Hunter. Joel, on behalf of Real Water. We think the best way to go through this is to rule on the objections as they come up. We specifically, I can only speak on behalf of my client, if we saw something that was objectionable, whether the plaintiff designated it, whether Terrible's designated it, we objected. And so if there are situations where there's testimony that we designated and no one objected to it, our position would be the court has nothing to rule on. If the plaintiff designated that same testimony, and for whatever reason, the court ruled that that particular testimony was out of bounds, so to speak, and objectionable, and the court excludes that. I wouldn't take that to exclude a quote by Real Water that may have that same language, but it may be offered for a different purpose. I don't know there's any other way to do it. I mean, if I would presume.
Sorry, can you walk back that last
Yeah,
sentence of what you just said? I just want to be clear on your
So
position.
let's say Real Water doesn't, because this is going to happen in the very next quote. For Nestle, and he worked in areas that handled milk products. That goes to, in Real Water's defense, that he was a qualified person. He handled various kinds of products, went through food safety. This goes to the punitive damages issue. We're offering that testimony to refute the argument that plaintiffs are anticipated to make that there was no quality control, nobody cared, that sort of thing. That's why we're offering that testimony. Terribles didn't object to that for our purpose. They may object to plaintiff's designation of the same testimony being offered for a different purpose. I think the only way to do this is to go through the objections that were made, rule on those objections, and if they don't cover somebody else's designation, in this case we're using Real Water, but I could use easily Terribles or plaintiffs, then that testimony would still come in.
Okay. But counsel, the challenge with that is, I'm hearing what you're saying. Until Mr. Pepperman said that orange writing and the way that you all did orange writing and then the blue with the underline for the same section on 47, right, 2 through 25, right. It's either objection. Terribles has raised an objection. I have to rule on each and every one of their objections. So I have to look at that entire section as they have objected to that entire section. There is not.
Well, then the flip side is I will argue against the Terribles' objections. That's the flip side.
Which you would have an opportunity to do so, because the point is there is nothing here that I have your analysis, right? The background, which you just gave to the court orally, right?
Well,
it's not in what is presented to this court for the depot designations.
There was, because under the rules, when we designated our sections of depositions, everybody had a period of time to object. I don't have the timeline in front of me. And if they objected to our designations, it would be before the court. Because they didn't object to our designations, in Real Water's opinion, those objections are waived. Whether they're from plaintiff or Terribles, it doesn't matter. Because they had an affirmative obligation when we made our designations to object.
My question goes back to, how would the court know that? I have two very short. I have
all of the objections in front of you.
And
if we go through all of the objections, we're not going to miss an objection. If they miss testimony, they waive the objection in our view. They failed to bring it to your attention. Hey, we object to this for a different reason. Real Water is offering it for this other reason. We object to it also.
Okay, but counsel, here's what I've got. Let's go to the very first one, because that's the issue, right? In the very first one. Before Mr. Pepperman spoke, the fact that it's in orange, okay?
And there's no objection to the orange
Well, but
designation.
you have to realize nobody told me about orange and what orange means, and there's
It was
no.
actually at the front, but I understand the court's confusion. This is
Because
very
you all
confusing.
asked me to start at the very first objection, which is page 47, right? Court doesn't have to go back and look at things that it doesn't need to rule on.
It's the color coding, Your Honor. The blue testimony is plaintiffs, orange is Real Water, purple is Terribles.
So how would this court have any idea when it's in orange in one, and then blue with underlining in the another, and there's
Should be
nothing?
consistent.
Yeah, Your Honor, let me take a stab at this part, because when I looked at it, it was not the way I typically like to do it and present it to the court, but I understand why it was done the way it was.
I understand for timing, you all were
Yeah.
each doing different things, but the point is, I have to make well-reasoned rulings, folks, and I need to have some idea, I need some, right? That's why I said, when you guys asked me off the record before, right, usually each person does it, and then it's just underlined if there's an objection. It tells me who's making the objection
Right.
and the basis. So if it's an objection as to one, that objection chart should have said Terrible's objection only as to plaintiff's designation.
So, Your
Or
Honor,
it should say Terrible's as to both, you know what I mean? Because you're basically, I'm gonna have to look at each of these and say, okay, with regards to plaintiffs, this is the ruling on this, and then But
And if there's no objection to the real water, then there's a waiver.
That's right.
but it's the same testimony, but it's the same testimony. So it comes in your case in chief and not during plaintiffs?
It would come, we would play it in our case in chief, but it's there, if we had designated, it's really, if we call a witness at trial and nobody objects, that testimony comes in.
That's
And
the easy,
that's exactly what's happening here. If we look at page 1, we'll see who's designated what. I don't know if the court would mind if you show us page 1. It specifically says who designated what right there.
and there's an objection chart. Courts
The
look at
objection chart is the
objection
one
chart.
that Mr. Pepperman provided, is very comprehensive. We spent about 8 hours
I saw that in the
working on
letter.
it, and those are the objections and the specific testimony that's being objected to.
Your Honor, if I can add, I think the problem here is how can Terrible Herbst object to our designation?
Counsel, I'm not going, that's not the issue. I understand I understand that you're saying that. I'm not gonna get into why you're saying that. But I have to focus on how I can make rulings realistically, counsels, okay? Which it was supposed to be easy of. That's why I started this off with, should I just start at page 47 and look at anything and the objection chart and then go to the testimony and look at that testimony, which you all agreed to. And then all of a sudden this pops up of, no, it's a double designation. It's only objected to by one and not the other. But there's no indication to this court. So I'll tell you, all my preparation on these multiple issues seems to be for naught, because one would normally view, I look at an objection chart, right? And then I go to the testimony and objection. And unless it says it's as to one party and not the other party, this court wouldn't have any basis to say who it applies to, because just like anything else, if you say an objection in open court, that doesn't mean that the court rules, right, overrules sustained for everybody and tells juries disregard it. Don't say you can disregard it for one, but you can't disregard it for the other,
Right.
except for in very, very, very rare circumstances. I gave my finding admission for one and maybe hearsay for somebody else, but you know what I mean? That's not what these are. So here's what I'm going to do, folks. I'm going to have to do it the long way. Okay. I'm going to go. Do you all at least agree that I start on page 47?
Yes.
Yes, Your Honor.
Everybody at least agree on that? Is there any earlier pages
No.
in Bushes? Somebody tell me. I start on 47, correct, plaintiffs?
Yes, Your Honor.
Yes, Your Honor. As we
Counsel
go
for
through
real
the-
water, do I start on
Yes, Your Honor.
47? Terrible Herbst, do I start on 47?
Yes.
Okay, I'm starting on 47. 47. 47. I see in orange designations 4702 to 4725. I see in blue 4702 to 4725. I see one of them's underlined, one of them's not. This court has not provided any indices that says the court should treat it as a distinction. So the court is going to look at the objections, and then I'm going to let Real Water set forth its position if it says it's a designation that it made and it has a position because it is listed in orange. And then the court can rule on it either coming in, coming out, or in part. The court's inclination would stand what it said previously. The court is inclined, let's go to the objections. The objections are relevance. The court would find it was relevance as to both parties because for both parties, it's background information as to what is somebody's skills, qualifications, background, history, and that generally would come in, and there's been nothing pointed out to this court of any reason why it would not form, not a trial objection. Even if form was a trial objection, there's nothing wrong with the form of the question. Foundation. The person knows his own history. Foundation. Overruled. He has a foundation. Speculation. It's not speculation for someone to describe his own background history. Overruled. Leading. This is not, since nobody has designated to this court who this witness is, and since I have to address leading. Leading would not be preclusion. Leading would be, and it's for the whole aspect. Each of those questions are not broken down question by question by question. Okay? The court's going to have a little concern about boilerplate objections repeated, but anyway, the court doesn't see that it's leading because the court has not been told who's actually asking the questions on this. So I don't even know if it's the client, if it's the witness of the party who's asking it. So I can't. It's not vague. It's a person describing his own background and history. Overruled. Misstates testimony. I'm not sure if somebody can misstate his own testimony as to his own history, so overruled. What? In part, with regards to the court had previously stated it had a question. It had a question with regards to the ending on this first designation which goes to 4725, because the question starts at 4722 and then ends at 4725 on trying to think, no, I don't, does not appear to be a full question when taken as this designation as presented to this court. The court can't look at the next designation. The court has to look at this designation because it's a question and answer. When I look at that segment, the court does have a question about whether or not that is intended. But realistically, in looking at the actual objections, the court's question doesn't really apply to the objection. So if you all have it in there, it's in there. All objections overruled. We're now moving on to the next one. The next one is 4801. Excuse me, that's the court's inclination. Would anyone like to be heard further? Counsel for Plaintiffs.
No, Your Honor.
Counsel for Real Water.
No, Your Honor.
Counsel for Terrible Herbst.
No, Your Honor.
Okay, so now we're going to 4801 to 4815. 4801 to 4815. Oh,
I think, wouldn't it apply, Your Honor, the same? I think it's a carryover of that.
I was going to give my inclination.
Oh, I'm sorry, Your Honor.
No, because there's a distinction between this, right? Because when you go back to the actual testimony and you start at 48, 48, now this one is different than the other one. The other one had the orange first and then it was underlined. This one has the underlying first and then the orange, and so I'm not sure if there's any reason other than just to see if the court's paying attention on what order you're doing these. Okay, why it's like this, or if it's just to try and see how much time I could really spend over the holidays trying to do all of this, but regardless, it is what it is. So 4801 to 4815 is the designation. The court is familiar that in the orange designation, it goes past 15, it goes 16 to 19. Since 16 to 19 has no designation of objections, the court is not ruling on it. It's going to be in because it's not otherwise designated as being objected to. So I'm only ruling on 41 through 1 through 15. When I look each of those, the court, let's walk through those again. So the objection, relevance, overruled. The reason stated with 47.2 through 25. Form, the reason stated 47.2 through 25, overruled. Foundation, same thing, 47 to 25. Speculation, one moment, please. Court has a question. I'm going to hear some argument on speculation. Because the reason why the court needs to hear an argument on speculation is actually, excuse me, the court, I misstated, actually be on foundation. I needed to hear an analysis on foundation on the basis of his knowledge with regards to the largest ice cream plant, as well as how you have to make sure all the ingredients, chocolate chips, peanut butter, jelly, strawberries, and everything were ready to roll and pumped. So I'm going to have to hear some argument on foundation on that. So I'm reserving on foundations, which means I have to reserve on speculation, leading. The court doesn't find it's leading. The court has to reserve on vague in light of the reasons I just stated with regards to foundation and speculation. The court overrules it on misstates testimony because he's saying what he is saying. He's not disagreeing or saying something different than anyone's pointed out to this court. So the court's inclination is overruled in part and need to hear analysis on foundation, speculation, and vague. Counsel for Terrible Herbst, you did the objection. You go first. Go ahead, please.
Yes, Your Honor. That portion concerning what happens with the ingredients the next day, we objected as lacking in foundation and speculation because Mr. Bush was in pre-manufacturing, and obviously what happens on a different shift the following day would be speculation on his part.
Okay, hold on a second. He's in pre-manufacturing, so a shift for a different day. Does he divide it out by shift? Because the reason why I'm asking that question is if you look at 4808, right? But I was watching over all the dash, pre-manufacturing before this wall that goes into production, and then it says we'd have to make sure. I don't see that he has distinguished a shift by shift. He was explaining his all pre-manufacturing. The reason for the court's question was this court has not been provided specifically, does he Is it disputed that he was in pre-manufacturing or not? That was really where my foundation and speculation is. I have no reason to know one way or another because you all asked me not to look at the first 46 pages, so.
No, there's no dispute that
Okay.
he was in pre-manufacturing, but on 4809, he talks about all of the pre-manufacturing before this wall that goes to production. I believe that's what he's referring to when he's talking about what happens the following day as the ingredients are pumped into the line.
Okay. Real water, since it's your orange designation as well, I'll let you be heard, then I'll let plaintiff, and then I'll go back to, I'll be with you all for a long time. Okay, counsel, go ahead if you want.
Thank you, Joel, on behalf of Real Water. It's not speculation. He specifically says chocolate chips, peanut butter, jelly, strawberry is firsthand personal knowledge on how to make ice cream. And to argue that his knowledge about how to make ice cream after working at the dryer's factory is speculation is absurd. This
You have to realize
objection
the
should be
court
overruled.
doesn't know what background information he may actually have. That's the reason why the court said it had to hear more on the foundation, which leads to speculation deferring. So
And
it is,
Terribles hasn't articulated why he doesn't have the personal knowledge. They've just assumed, oh, he must be in pre-manufacture. Where's the proof of that? Where's their offer of proof as to their objection? This is a speculative objection, and this is just making it up as we go along. Mr. Bush has had testified that he has extensive experience in manufacturing. We're offering it to show that he was qualified to hold his position at Real Water and that he did a good job. And you know, if Terribles wants to speculate as to his lack of personal knowledge, show us where he doesn't have the personal knowledge. Quote something from the deposition. You can't just stand up and go, oh, speculation, lacks foundation. There's no basis for that objection.
okay. Counsels for plaintiffs, do you want to be heard as well?
Join with Mr. Odou. It's his background. What it shows is argument, but joins with everything else, Mr. Odou.
Okay. Court's going to now the court's had an opportunity to have an understanding of the foundation because it's not self-subsumed within this small section. And unlike my testimony, I don't have the benefit of what he would have said questions before. Now that I've gotten that background, then it's overruled on all grounds, and the chocolate chips, peanut butter, jelly, strawberries come in. Okay. So now we're getting to the next objection. The next objection is page 60, lines 1 through 25. It's a Terribles objection, so let's go to page 60. Okay. Page 60 does not have any orange, at least presented to here, unless it's in invisible ink that I don't know about. So page 60, 1 through 25. Relevance, form, foundation, speculation, leading, vague, estate's testimony, expert testimony needed. Okay. I'm not sure how one objects to partway through a question, but counsel for Terrible, it's your objection. Why are you objecting partway through a question?
Your Honor, we
We'll
would,
cuddle up to management, right?
right, I see the issue there. We would limit our objection, Your Honor, to his discussion starting at 60, line 10 through 60, line 12. Again, his discussion concerning what happened at Nestle, we would argue is irrelevant, and that plaintiffs are trying to draw some inference on what happened at Nestle and what should have happened at Real Water.
Here's where the court's going to have to ask, how can he possibly misstate his testimony? Do you have any independent knowledge that he did or did not have training?
That he did not have training?
Counsel, you make a misstates testimony for the section where
Right.
the question was asked, right? The question that was asked, have you ever had HACCP training? The response is, at 60 line 11, years ago at Nestle, critical control points, that was part of it. You have an objection as misstates testimony. So I'm asking you, as was right, on what basis are you making an objection that misstates his testimony? Is there something independent that the court should be looking at where he has stated somewhere else that he did not have the training?
No, Your Honor. No, Your Honor.
Then why is there an objection to misstates testimony?
That was obviously a mistake, and we should have withdrawn it on that basis.
How is that leading, counsel?
Well, I mean, he tells him, and you've had HACCP training, that is leading.
I understand your relevancy. How does that go to foundation? Wouldn't he know whether he did or did not have training and speculation?
Yes, he would. So we withdraw that objection as well.
Which objections are you asking the court to consider, please, with regards?
Relevance and leading.
Okay, hold on a second. We're going to have two questions. I have a two-pronger here, please. First off, what's the scope, meaning the page and line numbers that you really wish the court to address? And then I need the objections that you need the court to address, please.
There are 60 line 10 through 60 line 12.
Okay, with that limitation, then which objections are you asking the court to consider, please?
Relevance and leading.
Relevance and leading. And for basis of a trial testimony, when you have agreed that this is a depo in lieu of live testimony, how would you like the court to address a leading? Are you somebody going to re-depose him, to ask it in an open-ended fashion? What are you suggesting that the court do with regards to the leading objection, please? And I'm going to ask everyone the same question, so stay tuned.
Well, we would withdraw it on that basis, Your Honor, and stick with the relevance objection.
Okay, thank you. Okay, so with that limitation, that means plaintiffs, you're up because I do not see a position from Real Water. Real Water, if it's not put on here in orange, then I'm viewing it based on what you all told me that you didn't make the designation. However, in fairness, since we have a change to scope and a change to the objections, in fairness, you may have not had that opportunity during your 8 hours of meet and conferring. So fairness, I think I need to let you say if you have something because of this change of scope.
Yes, Your Honor. Again, what's in orange is things that we added beyond the plaintiff's designation. And so because it's not duplicated doesn't necessarily mean we wouldn't be offering it ourselves. In this particular instance, HACCP training could be very relevant. We assume that the court may allow, I shouldn't say assume, the court may allow the plaintiffs to put on evidence that the Real Water employees didn't have HACCP training and failed an audit because of HACCP training.
But they didn't object to this.
They didn't. I'm explaining why it's relevant and why
Okay.
Terrible Herbst should be overruled. Terrible Herbst, as I understand it, objecting to it, saying it's irrelevant. It may be relevant. I don't believe Terrible Herbst's objection is well taken. If the court allows evidence of HACCP training to be put before the jury, then it's relevant. The objection should be overruled, Your Honor.
So is it now the position that even if there's not a orange designation next to the blue designation, either above the blue designation or below the blue designation, even if there's not a orange designation anywhere in the scope of this, that there still may have been a designation by Real Water, the testimony? I just need to know who I need to ask for each one.
Yes, Your Honor. And the way this worked was the plaintiffs did their designation, and if they designated somebody that we didn't, and there was testimony that was omitted, we would say, oh, well, for the sake of completeness, you need to add this. And so ours that appear in orange are, for the most part, except for a couple of depositions, additions to what the plaintiff had. So we didn't, why would we object to our own testimony? Again, the exercise is we have to go through Terrible's objections, and I'm responding to Terrible's objection.
Counsel, you can appreciate. The first two had one orange on top I was supposed to take into account. The next one had orange on the bottom I was supposed to take into account, even though there was no analysis. This one has no orange anywhere. So you can appreciate the court has to ask, am I still supposed to take it into account? Because I was told previously, if it had orange, take it into account, regardless of the orange on top or the orange on bottom. I'm supposed to keep looking through this. Now it appears I'm also supposed to take it into account even if there is no orange. And that's really what I'm just trying to get. If I need to ask each and every one or not. If the simple answer is you'd like me to ask each and every one, I will, regardless if there's orange
Yes, Your
anywhere in
Honor,
there.
there is definitely testimony that the plaintiffs designated that Real Water would be offering if they weren't even part of this case, hypothetically. So, yes, we have a response to a lot of these objections where we disagree with the co-defendant.
Okay. Plaintiff, do you want to be heard on the relevance only objections 60, 10 through 12?
Your Honor,
Or do you just ditto what?
Plaintiff joins in with Real Water's comments on this. The HACCP training is relevant. Training involving production of bottled water or ice cream. There are similarities in training, the HACCP training that can apply to both. So it is relevant. And Your Honor, just for one point, just because you'll see this the rest of the day unless we address it real quickly. A lot of these objections, these form objections, I will call them, you can tell by the actual question, and you've already picked this apart, but I just wanted to mention it again. 6010, it says, and have you had HACCP foundation training? I'm sorry. That's not leading, and it's from an opposing party. It's not leading. So I think I just want the court to be mindful. You see this same list of form objections throughout, and they have no application really to the testimony, Your Honor.
I'm hearing
In short order, we do agree with. We believe it's relevant for the reasons I
can
stated.
appreciate, I have officers of the court telling me that you all spent 8 hours in good faith meeting and conferring. This court takes attorneys at their statements here in court. If there's questions the court has specifically as to how something could apply, I'm going to ask you all, right? Because we're free to read the Nevada Rules of Civil Procedure on form objections and their impropriety.
I agree, John.
2019 revision specifically thereon. You got it. You all would love this to go in front of former Commissioner Bullock, Court of Appeals Judge Bullock, but I'm not there. I'm only a district court judge ruling on your objections. I'm moving forward. So, overruled under relevance for the reasons stated by both Real Water and plaintiffs. And realistically, free to read the list of objections that are proper trial objections, folks, but whatever. Okay. We're now in 61, 1 through 25. The objection is only, it says terrible, 61, 15 to 25. So the court has to presume that 61, 1 through 14 comes in. Is that a correct assumption? I hate to make assumptions, but is that correct?
Correct.
This is a moving target, folks. That's why I have to ask this question. Is that correct? Okay, terrible says it's correct. They're the one objecting, so I'm addressing that. So now we look at 61, 15 to 25. 61, 15 to 25. 15 to 25 starts with an answer. So I'm going to have the same question that I had previously, how partly having it midway through a question and answer. Now, if the court fully appreciates, we tell the jury that the question is not testimony. The question only gives meaning to the answer. However, for testimony, unless usually you have a question and an answer, but okay. So let's court needs to hear further argument on the relevance of whether or not Nestle incarnations on a 1 to 10. Court's going to reserve ruling with regards to the relevance, with regards to the fact that it starts at line 15. Obviously, I'm going to have a question on that because that's answer. With regards to form, well, technically, since the objection is only to the answer, it's creating its own form objection, but with regards to foundation, well, a lay witness, even under NRCP, or NRS 50, still can give their generalized viewpoint on how they would view something. That's not, and it's not speculation. It's not leading, it's not vague, it's not misstates testimony, and I'm reserving on relevance and expert testimony. Counsel for Terrible Herbst, that's just a court's inclination. Feel free to argue the other ones if you want to. Go ahead, please.
Your Honor, anything regarding Nestle incarnation and what happened at those facilities would be irrelevant and prejudicial.
Why? What's your offer of proof? I mean, honestly, the reason why I say that, and I appreciate your pro hoc, right? Okay. But you did pick a judge that's, guess what, licensed in more than one state, practiced for a decade in the state you're from, takes no position on that. We're different. We're Nevada, born and raised. But anyway, that being said, and that has no impact on any of my rulings, I'm just saying is, I look at these objections. Why would it not be relevant what somebody did? Every single case always goes back to what someone's prior employment history is to give a background. Not every case, almost every case. Let's not say every case. Many cases, right, gives background. Many cases if you're talking about a skill level, which is what's here, right, in the expertise, gives a comparison. So your global statement, I'm only going to your global statement. I'm only ruling on the specific, but when you make a global statement that everything is irrelevant, I'm gonna have to ask you for an offer of proof because.
Well, I didn't say everything is irrelevant, Your Honor. I
For
would agree,
Nestle
as I
Incarnation, yeah.
did mention earlier, that his background is relevant. To the extent he worked at either Nestle or Carnation, that would be relevant. But once we start getting into what happened there and the training at Nestle and at Carnation versus the training at Real Water, it becomes prejudicial. That becomes a comparison between what happened at Nestle and Carnation, what should have happened at Real Water, and they're just not the same, even in the same industry. One is dairy products and one is water, and one does not translate to the other. The offer of proof is his testimony concerning what was manufactured at Nestle and Carnation, which is dairy products, and what was manufactured at Real Water, which was alkaline water. Those are not on the same levels when it comes to food safety. If we're going to start doing comparisons with other non-parties, that would be prejudicial to Terrible Herbst to show that some other manufacturing process was somehow at an elevated level, and probably with good reason. When you're dealing with dairy products, it wouldn't necessarily translate to a manufacturer like Real Water. And those are the reasons for a lot of these objections as to the Nestle and Carnation. I'm not trying to suggest that there's some general objection. I'm trying to explain why we go further in objecting to questions that go just beyond mere background.
Okay. And since
then
your
the first
objections start at line 15, which is the answer, was that intentional or was that inadvertent?
No, that should have started earlier when he's talking about Nestle at line 13.
Okay. Does anyone view this waived or the court starts at 15 or 13, folks? Where am I starting?
13.
Terrible says 13. What does plaintiff say? I just want 13 or 15. I don't want the full version.
13, Your Honor.
Counsel for Real Water?
Sure. Lines 13 through 25.
Okay, so starting at 13. Go ahead, please. Then.
That's all I have, Your Honor.
Okay, so Real Water, you're next, and then I'll do the plaintiffs.
Thank you, Your Honor. There really is, and somebody's experience and background is very relevant. This is no different than somebody who went to college or medical school and performed surgery and they were asked to take out a splinter. What's your training and background and experience in surgery? Well, I did this, I did that. So you're qualified to remove a splinter? Yeah. In this case, he made ice cream. Is he qualified to make water? Yes. And that's really why we didn't object to this testimony and want it in. It goes to Mr. Bush's background, training, and experience in handling food items. He handled ice cream. Ice cream is a dairy product. Perhaps there are more regulations. I don't know that we asked him, but it goes to show that he is a qualified individual when he was making water.
Okay, counsel for plaintiff, I'm going to have a question for you. Designation of 24 and 25, but go ahead, your response to the others, and that's going to be my question.
Your Honor, I would join with Real Water, and I think you, again, hit the nail on the head. It goes to background and comparison. It establishes a foundation for him to be able to say what he personally observed and experienced at Real Water was far inferior than what he personally observed and experienced at his prior employment in the areas of HACCP, quality assurance, food safety, which is the same across any type of food or beverage manufacturing facility.
And lines 24 and 25, how are they relevant? But it just says and Carnation, and the answer is and. What was that?
I believe it went on to there may have been a cut or something, but it was intended to go on to the next page, which would completeness would say and Carnation. And what was that? So on a scale of 1 to 10, Carnation had a 10 quality control.
That's not before the court. The court only has this designate. And, yeah, it's not because the next section starts with 6219, so you can appreciate the court doesn't have the benefit of 62.1. And 1621 even designated?
No, it wasn't. I don't have the full transcript in front of me. I think it might have been some exposition outside of it, but we can eliminate 6124 through 25 and 6219. I think.
I'm not on 6219. I just was referencing that just as what the next excerpt. This wasn't like 47 to 48, which flowed to the very next page. There is a difference. So it's your flowing question. I just have no benefit to be able to view it.
We'll withdraw 6124 through 6125.
Does anyone object to the withdrawal of 6424 and 6425? Real water.
Sorry, 6124.
Sorry, 6124. Thank you.
24.
6124, which reads Q,
Okay.
and carnation dash dash. 6125, which reads and dash. What was that question mark? Any objection to plaintiff withdrawing that
No
designation?
objection, I'm withdrawing it.
Chairman Herbst, any objection?
No objection, Your Honor.
Okay, so the court's only ruling on 15 through 23. Overruled on each of those grounds based on what was presented in arguments. And just so we're clear on the does find it relevance, the court already ruled on form foundation, got the foundation based on, he's asking his own opinion of what it is, so it can't, he has the foundation, can't be speculation, it's not legal the way it's phrased, it's not vague, can't misstate his own testimony because he's asking to give it. Court also does not find its expert testimony needed because it's asking for his personal opinion, which falls within the lay opinion aspect of the NRS. Overruled. Okay, going to 6219 through 25. That's a terrible Herbst objection. Relevance, form, foundation, speculation, leading, vague, misstates testimony, expert testimony needed. Let's go to 6219 through 25. 6219 through 25. I understand, counsel for plaintiff, you were about to say that you wanted to withdraw 6219. Is that correct or incorrect?
Yes, Your Honor, correct.
Okay, so then now we're looking at 6220 through 6225. This is the reference on the Carnation scale for quality control. Counsel for Terribles, you had an objection. I read the various objections. Realistically, the court's inclined to overrule them all for the same reasoning because the background, the history, the explanations that were previously provided, that's only an inclination. And the only other thing I would have is on 6225, so I'm not sure if that's the end of the sentence or not because it ends, oh, yes, yes, I think anybody from the, and there's no word after the. So that one is a little unclear whether that's intended if a word is missing or if that's the end of his answer. But I'll stay tuned because I'll hear from plaintiffs when we get there. So, Counsel for Terrible, it's your objections. Go ahead, please.
Your Honor, I have nothing to add in light of the court's prior comments and ruling.
Okay, thank you. Real water.
Nothing to add, Your Honor.
Plaintiffs.
Nothing to add, Your Honor.
Do you want to address the 62, line 25 that ends in, I think, anybody from the? Is there a word missing, or is that just the way it stops, or what happens?
No, it continues on to 6301. The way Terrible Herbst provided their objections was by page. So some of the objections carry over onto the next box.
Oh, okay, so you need me to rule in addition for 6301. Okay.
6301 will be part of the
Back.
prior objection. Your Honor. Correct.
Okay, well, the court's going to delete after the words yes, yes. Because once he starts with I think anybody, that is speculation. So 6225 would end in oh, yes, yes, unless plaintiffs is requesting some.
No, Your Honor, that's fine with plaintiffs. Thank you.
Okay, and if it's out of context, then somebody needs to let me know. Counsel for Real Water, your position?
No position, Your Honor.
Counsel for Terribles?
Nothing further, Your Honor.
Okay. So overruled in part, it's granted with regards to speculation, starting after the words oh, yes, yes on line 25. And the court's ruling would be the same for 6301 because that's a continuation of the sentence. Does anyone want to be heard on 6301? That would be deleted based on what the court said with the oh, yes, yes. Anybody want to be heard on that, Terrible?
No, Your Honor.
Okay. Counsel for plaintiffs, do you want to be heard?
No, Your Honor.
Counsel for Real Water, do you want to be heard?
No, Your Honor.
Okay, so now we're starting on 6302, orange. That means I do not see.
We're going to end up withdrawing that, considering the other court rulings. I gotta see how the whole thing reads once we've chopped it all up.
Hold on a second. 60, no, it's not objected to.
It is not.
The next objection is page 82. So if you're withdrawing, talk among yourselves unless you want to say something right now.
Thank you, Your Honor.
Is there anything you want to?
Nothing further.
Okay, now I have a question. 6512. Okay. I presume that there's a typo because the next objection for the court to address starts with 6501, but yet it's underlined on the copy to the court starting at 6425, which is the beginning of the question. So was it the intention of the parties that the court should be starting its ruling on 6425 rather than 6501?
Yes,
Sure.
Your Honor.
Anybody disagree? You agree?
No, Your Honor. No from plaintiffs.
Not from Rule 1.
Okay. Hold on a second. I got a yes and 2 no's, so I might not have formed that question appropriately. I'll phrase it in the open-ended. And does everyone agree the court should start its ruling, even though it says 6501, that the court should really start its ruling on 6425? Does everyone agree to that, or does someone have a different position? You have a different position, please let the court know terrible your position.
I agree, Your Honor.
We agree, Your Honor.
Plaintiffs agree, Your Honor.
Okay, starting with 6425. Court has a question here. Okay. With regards to what's being discussed here, is it the Blaine and Amy that have been previously discussed in several different motions that are referenced in line 6502?
That's Amy Jones, Your Honor.
Okay. And Blaine is Blaine? That's
Blaine Jones.
Okay, that's what I thought. The reason why the court had that question is because you can appreciate the objection goes to relevance. One of the objections is relevance, so the court needed to be clear who the Amy and the Blaine was, although it appeared who it was. Okay. Court's inclined to overrule them on every basis, strongly overruling it on expert testimony needed as to who got laid off. But love to hear how that requires expert testimony, but sometimes people get in the mode of cut and pasting, so maybe it was a long day. Counsel for Terribles, it's your objections. Go ahead, please.
Your Honor, I have nothing to add on those.
Do you want to explain why it says expert testimony needed on who got laid off?
It probably shouldn't, but it looks like speculation as to what happened after he got laid off.
But why would that need an expert testimony?
It would not.
Okay. So, I'm sorry. So, you want to be heard? You don't want to be heard? What's the position?
Do not want to be heard, Your Honor.
Real Water, do you want to be heard?
Nothing further to add, Your Honor.
Plaintiffs?
Nothing to add, Your Honor.
Well, court's kind of, like I said, overrule the objections, and you heard what the court said about, I'm taking that as an inadvertent error on expert testimony, because who got laid off is definitely not expert testimony. Okay, so we're now on 8224 and 8225. The concern about 80, I believe you all are going to ask me to take 8224, 8225, all the way through to 8325, because it looks like the question starts on 82 and the discussion goes through to 83. Is that correct? Or if you're requesting something different, Terrible, it's your objection, so go ahead, please.
Yes, it actually goes all the way through 8405.
Okay, feel free to give your discussion. Go ahead if you wish.
And the objections, Your Honor, is this involves a discussion about customer complaints and the reporting procedures for customer complaints. But the problem with Mr. Bush's testimony concerning that is that he acknowledges within this testimony that he was not involved with customer complaints. He had not read the policies and procedures concerning customer complaints. And so anything he testifies concerning what would have happened or what somebody would have done with those customer complaints lacks foundation, calls for speculation. It's irrelevant as to what he's guessing at. I would agree this is not expert testimony.
Okay. Counsel for Real Water would like to be heard.
Nothing further on this one, Your Honor.
Counsel for Plaintiffs?
Your Honor, I struggled with the objection because he says, and this goes to the heart of our case, he says himself he didn't receive training on it. That's a point we're raising. It's relevant to our position that someone needs to know how to handle complaints, especially when you're dealing with someone in his position. And he said he didn't receive training, something different than he would have done at Nestle or Carnation. So, Your Honor, it is relevant. None of these objections make sense given where this testimony is coming from. The person is coming from the position he held. Your Honor, unless the court has questions, I just don't see how
I
they...
actually do.
Thank you.
And the challenge the court has is, if I look at lines 8315,
8 through 15? 8 through 15?
8315, here's the court's question. I'm just telling you where I'm going from. 80, here's a challenge. You have somebody, you're referring to an exhibit, which presumably, I'm going to have to ask whether you're planning on wanting to present that in front of the jury on something that he says he knows nothing about. If this were live testimony, it wouldn't come in, right? Because you can't present an exhibit and you can't discuss something that somebody knows nothing about. So that goes to some of the objections that are stated by Terribles.
Well,
At the same time, the court's cognizant of the question asked at 84.3 when it's asked about you didn't get any training to do with customer complaints. So the court's question really is, can't the 84.3 through 84.5 be treated separately in lines 83.15 through 84.2 be deleted because it's only referencing an exhibit that he isn't aware of, or are you saying that you have a position on those lines?
no, we have a position on those lines as well, Your Honor.
Go ahead.
Typically, and I will tell you, I've had this issue come up before. When we've introduced a document that a person in that position should have reviewed, it's an indication of the lack of proper educating on the part of the company, a lack of training, a lack of introduction to these documents. So it is important because he should have read either that document or a predecessor to that document, a prior iteration of that document. And so it makes a point here as to why perhaps their handling of customer complaints was so poorly managed, because someone in this position should have been aware of it. And so we want the jury to see this is a document or the type of document that this person should have been aware of and he was not. That's it.
Okay, Real Water, do you wish to be heard?
And I can tell you the context, Your Honor, because it was a Supreme Court case. It dealt with the failure of an employer to provide the employee with the non-drinking policy procedure for that business. That's where it came up in another Supreme
I'm
Court
appreciative
case.
of that. Okay. Counsel Real Water?
Thank you, Your Honor. Joel doing back for Real Water. This one's different in that it's talking about a procedure. It appears from 2014 before Mr. Bush worked at the company. They asked him if he had seen the procedure. No, he hadn't. And with his prior answer, the complaints went to Amy Brent or Blaine Jones. That pretty much takes care of it. So I disagree with Mr. Parker on this one.
Okay. So anyone dispute the court allowing Mr. Odou to speak since he did not specifically articulate an objection, or since you all have modified things as we're going along? Is it okay for the court to take into account Mr. Odou's position?
We have no objection to that, Your Honor. I don't mind Mr. Odou chiming in. I don't think he addressed the nature of the standard operating procedure, the SOP, but I don't mind, Your Honor.
Terrible Herbst?
No objection, Your Honor.
He's heading your way, so he's okay. So here's what the court's going to do. Court's going to grant in part, so sustain in part, overrule in part the objections. Something to look at? Oh no, okay. Sorry, I just want to make sure I get it kind of okay. The court is going to sustain the objections on relevance, speculation, and foundation with regards to 8315 through 8402. And its analysis is it's predating when his employment was, so therefore it would be speculative and he would not have a foundation and it couldn't be relevant. The court, in addition, based on the context of the prior questions and his response that it was not his area, and once again, he's even said he's not familiar with it, speculation, and wouldn't want to bring the document in when he's already stated that he hadn't seen it, was prior to his time, and nobody's established that it was available and something that should have been followed during his time. Therefore, court's ruling is what I just said. Okay, so that has got us. Next one. Wait, this is purple. Wait, hold on a second.
Your Honor,
I
this,
just made a ruling, just like to overlap some, no, I didn't make it overlapping the purple. Go ahead, please.
Your Honor, the next objection is 8406 to 8420 by plaintiffs, and we will withdraw that objection.
Okay, Real Water, did you have any objection in that regard?
We do not, Your Honor.
Okay, so it's withdrawn, so it comes in. Does that meet the needs of Terrible Herbst?
Yes, Your Honor.
Does that meet the needs of Real Water?
Yes, Your Honor.
Does that meet the needs of plaintiffs, since it was your idea?
Yes, Your Honor.
Okay. The court need not rule. So now we're at, that covers your objection to 20, that gets us to 21. Next one I see goes to 87, 1 through 25, which is Terrible's objection, but it's not 1 through 25, it's really 20 to 25. And I believe 1 through 25 is given as the background, so 80, now wait a second, hold on. Objection says 87, 20 to 25. Okay, I need a little clarity. The objection says 87, 20 to 25, but if I look at the underlining on the transcript, it starts at 8701. So can someone please tell me the breadth of the objection that the court's looking at? Is it 20 to 25 or is it all 25 lines?
It should start at 8622, Your Honor,
Does it, hold on,
and continue to 8725.
is that on the objection chart? You understand the objection chart I'm looking at, and it's not, there's not page number, so I can't reference your page number. But I can tell you the one that starts at the top, because the last one was plaintiffs. They withdrew theirs. Oh, thank you. Shane's got it up. The next one starts 87, 1 through 25. It says terribles, but then it says 87, 20 through 25. But is that really the 87, 1 through 25 / 87, 20 through 25 is really 86?
Yes, Your Honor.
It starts
Okay,
at-
hold on a second. Okay, so I'm really looking at 86, 20, 20, starting with 86, 20, 22. Okay. And does it go all the way to 25?
Correct, Your Honor.
Okay. Since that's different, let me go back and look at this one. Just a sec, please. Let me hear your analysis while I'm looking. Go ahead, please.
Sure, this is a discussion that is based upon hearsay. So Mr. Bush was advised not to drink real water off the line from Mr. Jones, as he talks about, and what can happen in the case where you do drink it directly off the line, including some symptoms that one might exhibit, including vomiting, etc. First of all, it would be hearsay based upon apparently what Blaine Jones told him. And second of all, it would be speculation, lacks foundation, is really expert testimony as to what medical symptoms one might exhibit if they drink this water off of the line. And that's the basis for the objection.
Okay, so then addressing 8720 where it goes back to Nestle, you have the same objections there.
Right. Actually, yeah, and it continues on, Your Honor. I just noticed through 8805 with the discussion concerning.
Wait a second, I can't get there yet because of an intervening orange line, which is only part of a sentence of a question, which appears to be real water, so. Is it by agreement of all the parties that I'm continuing on to a different? Because then I've got another orange section 8801, so.
Yeah, I don't know what the single line designation was, but the objections continue in the testimony concerning what happens in DeSante, et cetera, through 8805.
Folks, I just need to know the scope of the pages and lines I'm ruling on for this one, please? Which moving target would you like me to do, and which one? Because I appreciate Real Water might have a particular view on certain of its orange that doesn't have underlining, but yet there's blue with underlining. So just please give me the scope, folks.
Your Honor, it's just the testimony that's underlined in red. That's the portion that Terrible Herbst has an objection to.
Counsel, I don't believe you're answering the court's question. I appreciate you did these page by page, but they break up questions and answers, and I'm hearing that what was supposed to be 87:20 through 25 is not really 87:20 through 25. I'm really supposed to start on 86. Then I thought I was supposed to go 86 through 87 to 25, and now I'm being told that no, you really have to go 88 to possibly 5, and maybe even further on. So you can appreciate with those various different statements, I just need to know which one, please, you're asking the court to rule on, and you all agree, starting at which line and page and line to what page and line that you're asking the court to rule on, please.
Yes, Your Honor.
Let me hear from
86
Terribles first, and then I'm going to hear everybody else's position. Folks, I'm just asking what I'm ruling on.
Yes, Your Honor. 86, line 22 through 88, line 5.
Okay, is that agreeable to Real Water?
We think line 6 on 88, because the answer finishes on line 6. But yes, 86, 22 through 8806.
Counsel for Terrible, before I get to plaintiffs, let me see if Terribles will modify their 5 to 6.
Yes, Your Honor, that's fine.
Okay, so plaintiffs, are you sold? Is it 88:22 to 88:6?
8622.
Sorry.
86. Yes, Your Honor, we agree with that.
Okay, that's all I'm going for that. Okay, step by step here, folks. So, counsel for Terribles, did you have a full opportunity to set forth your position with regards to your objections from 86 line 22 to 88 line 6?
Yes, Your Honor.
Counsel for Real Water, do you wish to be heard? And I appreciate there's a couple of orange lines without underlines in that intervening section. Go ahead, please.
Thank you, Your Honor. Joul and Odou on behalf of Real Water. This is an issue that if other witnesses are allowed to testify that you're not allowed to drink real water off the line, then we believe this testimony would be admissible. Mr. Bush explains the reason why you're not supposed to drink the water directly off the line is because of the ozonation machine. No different than Dasani. You don't drink the water off the line at Dasani because they use an ozone disinfectant type treatment. And if you drink it immediately off the line, the ozone will make you sick. It's something that the employees were told, so it's not speculation that it would make you sick. In fact, some of the people experienced it, and it's not required of a medical opinion because this was the reason for the standard operating procedure of not drinking it off the line. However, if there are other witnesses who speculate on this topic and offer rather derogatory testimony that implying that there was something wrong with the water and that it was fed purposely to the homeless to make them sick, in which case this testimony would be relevant to explain, no, they didn't do it on purpose, and this is the reason why, is because of the ozone treatment used to kill bacteria.
Okay. So, non-hearsay purpose or hearsay purpose, are you concurring that it's hearsay on what Blaine told him? Or are you saying it's a non-hearsay purpose since, hold on, let me make sure, contained within this one, wait, hold on, it does have a hearsay on this one, okay.
So as, whether or not the water would make you sick, the truth of the matter asserted, that's not relevant. It's relevant what he was told in their conduct, which is to not drink the water off the line. Moreover, this was a company procedure not to drink the water off the line for that reason. So it also goes as part of their methods of doing business.
Okay, counsel for plaintiffs.
I think I agree with Mr. Odou. There's definitely a standard operating procedure about not drinking the water off the line. Multiple witnesses testified that if you drank the water off the line, it would make you sick. Some did mention the ozone explanation. I think that is perfectly relevant and admissible as a potential explanation for this. Other witnesses testified to having a different understanding or no understanding, which I think is also equally relevant and admissible. So plaintiff's position would be that this testimony is relevant to that issue and SOP, and it's not hearsay because it's not offered for the truth of any explanation that they were told. It's offered to show the effect on the person who's testifying, is to say, this is what I understood the problem to be, and this is the reason why I understood it to be a problem.
Okay, I need to ask both plaintiff, I'm going to circle back on the Nestle question. The Real Water addressed DeSante a little bit, but since I also have a relevancy objection, I understand Real Water's position on DeSante, but let me circle back to you first, so I just clear up your position on the Nestle, and I'll circle back to plaintiffs, then I'll give last word to Terribles. Counsel.
So, Your Honor, on the, again, the comparison to Nestle, again, if other witnesses are allowed to make that kind of comparison, it could be relevant. We don't know at this time. We don't know what other witnesses are going to say. We've objected to the testimony, particularly of some of the witnesses who are trying to smear real water and say, oh, well, you could drink water off the line if you got it from Nestle or from Pepsi or some other non-DeSante water. And again, it's a smear. It's not relevant. That shouldn't come in. But if it did come in for some other reason, then we would want Mr. Bush to rebut it. And so this is one of those where whether or not we would be offering this testimony or objecting to this testimony depends on what would happen at trial.
So how are you asking the court to rule today?
So for the court's purposes today, we would want a conditional
ruling is
ruling.
a court's
If somebody
ruling.
opens the door and this becomes relevant, then it would come in. If
So
the
you
door
want
is
it
not
out,
open,
so you want it out unless there's door opening? But I didn't
would
see an
want-
objection.
we would want all evidence that claims that people drinking water off the line and became sick excluded because it has nothing to do with hydrazine. This case is all
Did you
about
object, though?
hydrazine poisoning, not ozone contamination or poisoning or ozone making somebody sick. It's distracting to the jury. It's prejudicial. It should be out.
Did you object? I didn't see your name under any objections, and as we started today, I heard you say you had no objections on behalf of Real Water on any of these.
Because it could likely come in through other witnesses.
Could likely, okay, but I have to rule on Mr. Bush, because Mr. Bush is coming in depot only,
We took
correct?
Mr. Bush first, and so at this point, we would say it should be out. Obviously, the court has made a number of rulings where we would have to seek a sidebar and some issue may have a door open. This would be one where the door could be opened in other ways.
Right, but I have to address whether or not you waived your objection, because there is no objection stated. It doesn't matter which order the court took it, right? It's the objection
Right.
list, is the objection list, is the objection list.
That's right.
And there's no objections raised by Real Water, but I'm hearing you verbally.
That's right, because he explains it. I'm actually talking about the relevance of it. If the explanation is no longer relevant, then we might have an objection to it. But at this point, it appears this testimony is going to be relevant. But we can only do the best we can in trying to anticipate the evidence the plaintiff will offer at trial and what may or may not be admitted.
And the reference, when you drank the Nestle water when it came off the line, would that make you sick and vomit? No, sir. Super clean place. No. The water was ... no. That was actually my
Yeah, that's
question
not
on
really relevant
relevance,
to
huh?
anything.
Pardon, you're saying that's relevant?
It's not really relevant to anything. I'm agreeing with you.
It's a question. There's a question mark. Are you saying that's relevant? Like I
Yeah.
said, the challenge here is with the multiple objections. I have to look at these right with the multiple different ways. Okay, and since it's not a question by question, you all are asking right groups. I have to take these pages now. Okay, counsels for plaintiff. Looks like there's two areas of questions, right? One is the general drinking it off the line at Real Water. The other is the DeSante, and possibly a third the Nestle, or maybe you're grouping Nestle and DeSante together. So go ahead, please.
I would, so let me address the issue. The issue is there are multiple SOPs from Real Water. It's the evidence that you can't drink the water off the line, and that if water was going to be delivered for consumption in a shorter period of time, they were supposed to put less concentrate in. Our expert, Dr. Najam, and our argument is that's an indication that Real Water knew there was a problem with hydrazine because or something with the concentrate that required inquiry into these issues of why are people getting sick when they drink it right after it's made? Why do they need to put less in if they expect the people to drink it sooner? Those are problems that we think are inquiry notice issues, and we have experts to testify on them, and it's consistent with real water SOPs. Their argument is, oh, no, it's not hydrazine, it's this ozone filtration that we use. So that's an argument over the evidence. They're entitled to that argument. If they want to have the testimony of, say, it's ozone, or that's why, or DeSante used it, had the same problem, I think they're entitled to present that testimony. But to exclude this testimony from any of the witnesses about being sick off the line, or the SOPs, or less concentrate when it's delivered sooner, that's all relevant.
Okay, counsel, as you know, the court's ruling. Section by section, as I'm using the term section because it's not page anymore, it's not question anymore, how you all are asking the court to rule. So I'm looking at Bush's testimony in this particular section. So I understand you feel it's relevant. I've heard your things. How is Nestle, when you drank the Nestle water, came off the line, would that make you sick? How is that addressing the relevancy objection raised by Terribles? How is that relevant to this case? What happened at Nestle?
Mr. Bush is testifying, this is how it was at Real Water. That wasn't that way when I was at Nestle. It's a comparison. It's relevant just for purposes of the foundation of his testimony, saying this is how it was at Real Water, was different at Nestle.
How is it relevant to what happened at Real Water? Are you saying Nestle's was a similar electrolysis-based water, alkaline-based water?
No, Your Honor.
Then how is it relevant?
Because Nestle's didn't use the concentrate or the same electrolysis process. They weren't adding the same thing to their water, and they didn't have this problem of people getting sick off the line.
Okay.
And he says it. Look, when you drank the Nestle off the line, would that make you sick and vomit? No. Super clean place. No.
Right. But the court's question was, how is that relevant to the claims and defenses in this case before this court, which you're going to present to a jury? Okay. So here's what Terrible Herbst, I said you get last word if you wanted it. You've heard some various different things. Do you want anything else?
Nothing to add, Your Honor.
Okay, so here's what the court's ruling is. The court's going to overrule in part and sustain in part. It is sustaining the objection as to relevance with regards to line 8720 through 8724. The court does not see that that's relevant. Note is brought forth any way that would be relevant because it's not even a similar type water, similar processes of water, etc., or even a time period similarity, etc. So that is out. With regards to the remaining, the other bases of the objections are overruled. With regards to the hearsay, let's go through them, and I'm walking through a variety of them in the various different sections that are on the objection chart. I've already addressed relevancy. The foundation, he would know what it was, what he would told, everything. Misstates the evidence. The court at this juncture, what's been presented, can't say that it misstates the evidence. Of course, that would be subject to an opening the door, whether this is utilized for impeachment or whatever purpose it may use. It says it violates a motion limine. Nobody told me what motion limine it violates. Right? It says MIL. Oh, I'm sorry. I misspoke. That's on the plaintiff's one. I misspoke. Sorry. It's not leading. And counsel for Terrible, you understand the court's getting very concerned as I keep going through these, and it appears to be a series of boilerplate objections that are not narrowly tuned to each and every one of these sections. So that is concerning. It's not vague. Nobody's told me any reason why it misstates testimony. It's asking what he was personally experienced, so not seeing any basis on why expert testimony. It's not asking why. It's asking observations, right? Feel, touch, smell, etc. on lay witnesses, not expert. As far as the hearsay, Real Water has articulated a non-hearsay reasoning for it, so the court can't find that it's hearsay because whether it's true or not doesn't seem to be the purpose. It's a knowledge-based purpose, a non-hearsay purpose, so it's not hearsay. That then takes care of That got me to 88-6 by agreement of the parties, which now means the court now needs to go to, hold on a sec. 88-12 through 25. 88-12 through 25.
Your Honor, I would ask that the objections be grouped from 88-12 through 90 through 7, which is essentially the same discussion.
Okay, the court's going to have to ask a question because when you get to 89, 1 through 25, it's highlighted in yellow, but nobody's told me what highlighted in yellow means. Wait, hold on a second. No, it's not in my cross-reference. I didn't think it was. So what does the yellow highlight? Says those super important objections, super non-important objections, or they have some relevance, or somebody just got out their yellow highlighter?
The testimony in yellow is real water's designation.
No, I think you're incorrect. Go to the objection chart, please. The objection chart is highlighted in yellow. That's why the court was asking.
Oh, Your Honor, I apologize. Those indicate that the objections on the record were left in.
Objections on the record are left in the actual testimony, so the court has to address the objections on the record, and they're not for the first time brought up in this, or if you're saying something different.
No, we removed the objections from the cut because that would play on the video.
I really do need this top secret decoder key, please. Counsels, I mean.
I'm sorry, Your Honor. You can disregard those highlights. They don't mean anything for our purposes today.
Okay.
I agree, Your Honor. I think it was typo.
But no, he was, okay. So, counsel, go back to your request, since I was focused on if the highlights meant anything. Your request was to start at 80, which one?
12 and continue through 90, line 7.
Does that work okay for real water?
Yes, Your Honor.
Does that work okay for plaintiffs?
Yes, Your Honor.
Okay. Let's write notes. Okay. 97. Okay, so. Okay, first I'm double checking. They're the same exact objections. So go to 88. You really want the discussion of the wrong exhibit between 46 and 45, folks?
I mean, it's vague, but if they're willing to take it out, we can withdraw that.
Well, I'm asking plaintiffs. I mean,
Yes, Your Honor. We don't need the exposition in there.
so let's go back to the actual scope that you would like the court to rule on, please. Counsels for plaintiffs, are you having the court start at 88-12, or are you having the court start somewhere else?
I think to identify the email at 8812 through.
But it's saying it's the wrong email exhibit number, right? Isn't it saying it's 45 when you get to 23?
Eighty-eight 12 through 8816, and then 8823 through 8824.
In, out, what's the end of your
Those
sentence?
two would be in, and then start at 8903.
Counsel, you do realize, first you're talking about exhibit 46, then you say, no, it's really exhibit 45. Do you want to confuse the jury that there's an exhibit out there that they're not seeing?
I think it's just important to reference the email chain and what it is. We can scrub references to the exhibit numbers.
Why don't you say what your proposal is, please, so that I can see if people are on board, just so I know the scope of what I'm rolling on, please.
Okay, why don't we start at 8813 at this is an email chain through 8816.
You all maybe want an agreement that says that you edit out the portions on 8813 where you just reference an email chain, and then you start again with the answer at 8902, yes, I see 45 email, I do, and then you delete the intervening back and forth on whether it's 46 or 45. I'm not requiring it, this is purely a question.
Yes, Your Honor, I can do this. We can do this after if we just start on 8903 for the purpose of the objection.
Councilor Terrell, would that meet your needs?
Yes, that's fine, Your Honor.
So, Councilor Plaintiff, are you withdrawing the sections from 8812 through 8901, but you're going to request a certain sentence in there that just identifies something about an email chain, which may be a part of 8813, or what are you requesting?
Yes, Your Honor, exactly that. That's what I'm requesting.
Okay. Counsel for Real Water, your thoughts?
So we're going 8812 through 8901.
Here's what I understood Counsel for Plaintiff was saying. That he wants some language similar to directing your attention something. This is an email chain between Shani Castillo and a customer named Watkins, spelled out Watkins, and you are not on the email chain. Some language like that. Then he wants it to pick up at around 8902. Yeah, I do. I see a 45 email. So that you delete the intervening back and forth, whether it's 46 or 45. Is that correct, Counsel for Plaintiff?
Yes, Your Honor.
How you all work that exact language would be up to the parties, but that's what I understood.
And that's fine, Your Honor. I think I'm just going to leave it there. That's fine, Your Honor.
Counsel for Terribles, does that meet your needs, or since it's your objection?
Yeah, in terms of the vague objection, I think that covers that.
Okay, but do you wish those lines to be taken out, or do you wish the entirety of 8812 for the court to start its ruling on?
I think we can work with Mr. Pepperman's idea of editing what he wants to refer to.
Okay, so then are you really asking the court substantively to start making its ruling around 8902 through 90, line 7, page 90, line 7? Is that correct or incorrect?
That's correct, Your Honor.
Everyone on that same page or a different page? Does that work for Real Water?
Yes, Your Honor.
Does that work for plaintiffs?
Yes, Your Honor.
Okay, Councilman Chairman Herbst, go ahead, please, if you'd like to discuss.
Sure, and this is one we, Your Honor, had talked about during motions in limine as deferring. This refers to an email complaint by Mr. Watkins or his wife concerning a hospitalization to Real Water, and that's based upon what is hearsay, actually double hearsay, the email itself, as well as what the doctor told the husband in the hospital concerning stopping to drink Real Water. So we believe that none of that testimony is relevant. It's certainly calling for speculation that lacks foundation, requires expert testimony as to the true cause of Mr. Watkins' hospitalization. And then it kind of morphs into a discussion as to what would happen at Nestle should there be a report, something like this. And that goes into a complete shutdown of a plant. And the discussion concerning what would happen at Nestle would be irrelevant and certainly prejudicial. May also be speculation as to what the entire plant would do given Mr. Bush's job at Nestle. But certainly involves hearsay and is not relevant as to what would have occurred at Nestle.
How does it require expert testimony?
Because he seems to be rendering an opinion as to Mr. Watkins' illness and what was the cause of that illness and somehow linking it to alkaline water. At least that's the implication when there's the quote concerning the hospitalization of Mr. Watkins
But he's just reading that, that's in the question, that's being read by the, I don't know if it's Mr. Kemp, whoever's taking the depositions, whoever's taking the depositions.
Right, and he's getting in hearsay by having Mr. Bush agree or acquiesce to that statement.
Right, oh, I'm sorry, the court's question was how is it requiring expert testimony?
Because it talks about Mr. Watkins' hospitalization and the cause of his hospitalization being linked to alkaline water, when we have no testimony from his doctor indicating why he was told not to drink alkaline water and whether that truly was the cause of his hospitalization or not.
Okay, looks like the only objection Mr. Kaufman had was Mr. Forum, but Real Water, do you have a position on this one?
Your Honor, we took up the same issue someplace else, so I could certainly mimic those arguments now or make them later. But
Sorry, you took them up in.
the issue here is they showed this document to Mr. Bush and he didn't know it. So we don't think we raised the issue elsewhere and don't believe plaintiffs can backdoor it. So the question ultimately is, can this email come into evidence? That's the ultimate issue here, and you can't backdoor it and show it to somebody who's never seen it and say, "Have you seen this?" "No, I've never seen it." "Okay, move to admit." So it's the underlying issue is the admissibility of the email. We've took that up in a motion to eliminate. We've argued it elsewhere. We didn't think we had to re-argue it here because Mr. Bush has nothing to add on it. He never saw it.
Counsels for plaintiff, I have to ask you a two-pronged question. One, and your position on taking into account what Mr. Odou's statement was on behalf of Real Water, since there is not a specific objection listed on your objection chart for purposes of today's hearing, but realizing the motions eliminated were what the motions eliminated were, my first question, and then the second to address the substance of what the objections raised. Go ahead, please.
Your Honor, I think the court's correct. This is a two-parter. Part of it I want to address, and the other part I can reserve for Mr. Pepperman to address. But the first part of your question, in my opinion, Your Honor, addresses consumer complaints like the one involving Mr. Watkins. And we have discussed this at length, Your Honor, and we brought to the court's attention the Supreme Court decisions dealing with this particular issue. So first, I want to note that this is not a backdoor way of discussing customer complaints. We've discussed customer complaints in the motion in limine hearings, and we've addressed with the court several of the cases that touch upon the admissibility of customer complaints. So, Your Honor, just to start this out in terms of customer complaints, because this I think will save us time with three others that deal specifically with customer complaints, so we won't have to re-plow this ground. Your Honor, you're familiar with the Krause case. It's the Nevada Supreme Court case 117, Nevada 929. It's a 2003 case, Your Honor, and it deals with similar acts, prior and subsequent, being admissible, customer complaints. And in fact, and we may have that, it's on the screen, Your Honor. And if you were to go to page 5, speaking of similar acts, this is the latter case, Your Honor. I'm sure the facts probably will come to you as we discuss it.
I'm familiar with it. Had my own ladder cases. Go ahead. Been cited a lot. Go ahead.
Yes, Your Honor. And it discusses at the bottom of page 5 similar acts. And I'm going to approach the screen if that's okay, Your Honor.
Yeah, of course. Well, you know, as long as you're near a microphone,
Yes,
this
Your
wonderful court recorder is going to be.
I'll go right next to this one. And so if you go down, go up. You get to go further up. Page 5 for me is probably page 2 here. Go further in towards the beginning. Right there. Similar acts on the left, Your Honor. It says similar acts, accidents actually. It says Krause at Home Depot assert that the district court erred in denying a new trial after the depositions of Eggers and Bloomquist was erroneously presented to the jury. What's important goes a little further down. It says the district court, however, instructed the jury to disregard. And a little further, here we go. Stop right, no, go back up a little, right there. Further, we are of the opinion that the Bloomquist deposition probably should have been admitted as evidence of a substantially similar accident. Bloomquist was injured as he descended his ladder, and although he did not state that he actually touched the release lever, the jury could reasonably draw this inference. If you stay right there. The court presumes the jury follows the district court's instructions, Your Honor. That's really not that important. The point is, it talks about similar accidents. We got the customer complaints are of similar accidents, or not accidents, but similar incidents. And one thing that a lot of people miss in this case, Your Honor, which we paid attention to, of course, in the footnote. If you go to the footnote section, all the way towards the end, there we go. Number 20, footnote number 20. This is the Harley-Davidson court decision, Your Honor. You're familiar with that, 106 Nevada 533. Noting that minor differences in accidents do not warrant exclusion. I point that out because today we have 4 depositions and designations that have been made and objections, and the majority of them deal with this issue, which I'm trying to plow the ground now so we won't have to do it later. If you also look at the Needy versus McNeil case, we cited this in one of our briefs. This case also deals with similar incidences, and I would say a point, we go to page 10 of 18. Oh, go up. Go further up. Go to Roman numeral 4. You'll see a sec. That's Roman numeral 6. Go to Roman numeral 4. Okay, here we go. So, nope, stop right there. It says, McNeil contends that the district court erred in admitting into evidence case reports. These are drug experience reports, Your Honor, very similar to what we have here. Typically, you see these in the drug type cases like you've dealt with before. And it says here, the district court found that the reports were not hearsay because Beniti offered them to prove notice and not for the truth of the matter asserted in them, which is exactly what we're talking about here, Your Honor. And so what you'll hear later on today, which is I think somewhat similar to what you're hearing now, is they want to exclude them based upon causation. They're going to say, well, causation has been admitted or established by the court. Well, it also goes to notice, Your Honor. And then if you go, put it smaller. I want to start where it says, second, McNeil contends, but I want you to put 2 pages together. There we go. Go further. Okay, right there is good enough. Second, McNeil contends the cases reported were not similar to Beniti's case and therefore not admissible to prove notice. McNeil points out, and this is weird because this case has some acute liver issues. McNeil points out that alcohol history was unknown in some of the reports and that the acetaminophen dose is unknown in others. McNeil notes that most of the reports involving alcohol consumption involve chronic alcoholics, but that Beniti was not an alcoholic. Finally, McNeil claims that these reports are inadmissible hearsay because Beniti relied upon them for the truth of the matter contained in them and not just to prove notice. Your Honor, this court found that was incorrect and found that the district court did not abuse its discretion in admitting the DERs and case summaries because the plaintiff offered the evidence solely to prove notice. If you go further up, slow down. Here we go. And so, right here it says, we find, highlight that paragraph right there. We find that the district court did not abuse its discretion in admitting the DERs and case summaries because the plaintiff offered the evidence solely to prove notice, Your Honor. Again, these are strict product liability cases. These are directly on point, and these are Nevada, well, Beniti is not, but similar decisions looking at prior and subsequent incidents. And then finally, Your Honor, this is one that you're familiar with. Typically, this is used for a different reason. The Beatty versus Thomas case is not necessarily for this issue. But if you could go to that case, thank you. And this is the 1983 Nevada Supreme Court case. This is a medical.
It comes up a few
case.
times.
It does. Way often for this issue, Your Honor. But not for this issue, I should say.
Right.
But if you go to page, keep going up a little bit. So, right there. So go up just a little bit more. Stop right there. So it says the evidence that Metasonics had not been previously sued. They tried to get this absence of case of lawsuits in, Your Honor. And part of the holding in this case I thought was important here is the this paragraph says here, at one point during the 3-week trial, over appellant's objection, the court admitted into evidence testimony on behalf of Metasonics that had never before been sued regarding the Doppler. This was error, which is consistent with the court's ruling on TETT's MIL that we discussed 2 weeks ago. Then it says, in strict tort liability cases, evidence of prior or subsequent mishaps similar to the one in issue involving the same product are admissible to show faulty design or manufacture or other elements of the strict liability cause of action. Citing to Mapes, which we've discussed at length here, Your Honor. So, Your Honor, these 3 cases support that these portions of the deposition should not be excluded for purposes of hearsay. And they shouldn't be excluded for the other reasons because they're going not to prove the matter asserted, but to notice given to the defendants.
I
And I know that took a long time, Your Honor, but I promise to you it will save time on the other ones.
No worries. Okay. So we circling back then to, I mean, we're not doing multiple horses and riders unless I have agreement by everyone, since I've got 2 for each. So let me hear everybody else's position. Are you okay with 2 people speaking or not?
Your Honor, he's not going to speak.
I think Mr. Parker covered both topics.
No worries. Okay.
That way we save some time.
Here's the court's ruling. Remember, the court's dealing, well, I'm going to call it 80-12 to 97, but the modification that I'm really looking at substantively, the smaller portion. The court is going to grant in part and overrule some of the injections. I am granting it on foundation and speculation. Realistically, while I'm fully appreciative of the presentation by you, Mr. Parker, he says on his face, and it even says, I'm not suggesting you have gotten the email. I'm just asking if you knew anything about on the second page. Well, he says he didn't. And so you can't bring in an exhibit and a whole discussion on something that he's acknowledged he's never seen, never heard. You couldn't do it live. You can't do it by dep. And that's only ruling is with regards to the deposition of Mr. Bush. So it's speculation and it's foundation. Those are sustained. With regards to the hearsay, for this purpose, for Mr. Bush, I'm sustaining it, not taking any broader perspective with regards to the document itself, the email itself. I'm talking only in the context of these specific objections to this particular section of Mr. Bush's deposition as phrased with the question and answer. The rest of the objections are overruled. And you want to go through my analysis of why they're overruled, how there's no expert test. I mean, it's not vague, it's clear. It's not expert testimony asking him what he knows. Anyway, and for the additional section with starting on lines 89-18, which is not really a question, but I have to treat it first as a question. Really, the answer starts at 89-19. The additional for that portion, I'd also would sustain the relevance because is an example of what they might do at Nestle. Here would not be relevant. It doesn't fall within the various categories that have been discussed in previous sections. So that's the court's ruling. Moving on to the next one. We have now only gotten partway through in 2 hours, less than 100 pages of one depot. I'm not sure where I'm going to find time for you all, but we're going to have to deal with what we have to deal with. So next one, and then we're going to do one more, then we're taking a break, folks.
Your Honor, have you ever considered taking these in on simply
No.
the documents?
No, I
Okay, I'm
can't.
just asking.
There's a very good reason. During what part of what day would I have time to do it when I'm in trial and hearings and every other matter?
I just asked.
You all get
because
to
I've
have the
had-
opportunity to walk through. Plus, I have to, as you can appreciate, this has been such a huge moving target, right? I don't have the secret decoder ring that tells me whether to include highlights, not include highlights. Include things that may be in orange that may not be objected to, but may really have an objection to. The portion of a particular things. As you can tell, every one of these has had a modification and moving target here in open court, so you can appreciate it. It would be a wasted effort to try and do these without the benefit of counsel explaining what they really mean versus what was presented to the court. So,
Understood, Joanna. I was
You
trying to
cannot-
find a way.
yes, but how? When?
I don't know the answer, Your Honor. Like I said, I was trying to find a way for you.
Yeah, no, I appreciate it. If I had this easy with an analysis and it wasn't a moving target, but look at the number of objections I have. Look at how this has morphed each and every one. I don't see any possible way I could do it without you all. Because, right?
No, fair enough, Your Honor.
So, going to the next one. 91-18 through 25.
Your Honor, we would ask that this be grouped and extended from 91-18 through 95-08.
Point taken, Mr. Parker?
I didn't know if she would go to 95-25 since that seems to be the next full.
No, we're gonna cut off at 08 and leave and withdraw the remaining.
Okay, that's great.
Do you see why I cannot do this without you all?
Point made, Your Honor.
I mean,
And I won't add much, Your Honor, because this goes back to the discussion about getting sick when drinking real water off the line, which I believe Your Honor already addressed earlier. I mean, we objected, we don't think it's relevant and would require some expert testimony to describe what happens and why Mr. Obed was experiencing the symptoms that he is describing to Mr. Bush during this line of questioning. It's basically hearsay, Mr. Obed telling Mr. Bush what happened to him and what could happen to others if they drink it off the line. I do think the testimony is vague when it comes to his discussion on chlorine in a swimming pool, and that's it's not, the question doesn't invite the answer, but the question starts at page 93 and the answer continues, 9302, and the answer continues through 15 about chlorine and how that somehow correlates to real water. I think it's too vague. It's also irrelevant. What can happen in the pool, and with that, we'll submit.
You understand on this one, you have some different objections for certain of the sections you're now asking the court to take together. So am I taking the section that has the most objections? Am I having to sub-rule on certain subsections of certain sections, which you're now asking the court to rule on those different objections?
We would stand by the following objections, Your Honor. Relevance, form, foundation, speculation.
Hold on. Okay. Relevance, form, foundation, speculation.
And hearsay. An expert testimony needed with respect to the symptoms and what happens drinking off the line. And then the vague objection just to the discussion on chlorine.
And which sections would that be, counsel? I mean, you understand you're now asking the court. I mean, yeah. Folks, this has been a very challenging 2 hours with this moving target, okay? You all purportedly spent 8 hours. I have ones that aren't even in sections, moving targets on which objections, and now not even parsed out to which objection may apply to one particular subsection of now a broader section that you're asking the court to do. At least give me the page and line references, not the discussion, and I'm supposed to guess which part of that is going to be, please.
Yes, Your Honor, 9302 through 9315 is the discussion on chlorine and is vague.
And that's the only part that's vague?
Yes, Your Honor.
With those qualifications and those changes, counsel for Real Water, do you wish to be heard?
No, Your Honor.
Counsel for Plaintiffs, do you wish to be heard?
Your Honor, if anything's vague, it's the objection. This is all testimony from the production manager at Real Water testifying to his personal knowledge and experience and his understanding of the way things work.
Can you jump to hearsay and misstates testimony?
It's-
I mean, realistically, feel free to go through all of them, but those are the ones the court's looking at.
How could he misstate testimony?
Oh, I'm sorry, wait, misstates testimony was withdrawn. Hold on a second. Hearsay, expert, and vague. I mean, do whichever one you want, counsel, because you understand we're not going to do this the rest of the afternoon. This is a colossal waste of time with this changing, moving, everything. I mean, you all have to get this clean and clear and give me my secret decoder ring that tells me what I'm actually looking at clearly and concisely. Not a whole breadth of basically, you know, the plethora of objections that are potentially available, some of which aren't even trial objections, and then moving targets with different sections. I mean, you have to tell me which I'm looking at, folks.
You are 100% right, Your Honor. This is not fair, but I would point out
But you
that
keep asking me to do it, and I'm trying, but it's getting worse and worse and worse because now I've even got subparts with different objections with a different portion of a section that I'm supposed to now be looking at for only one objection, but not the other objections, and other portions I'm supposed to be ruling on other objections. So am I doing this? I mean,
these aren't plaintiffs' objections. These aren't Real Water's
counsel,
objections.
I'm not putting, I mean,
I mean,
this court has to be able to have things in the manner that you would properly give to any court for a court to make a ruling. That's really the simple answer.
I agree, Your Honor, but Terrible Herbst here is objecting to pages of testimony, and they're really not offering any reason that's worthwhile of the court's time here.
Can you respond to theirs? We're going to get through this one, then we're going to take a 10-minute break, and you all are going to talk during that 10-minute break and figure out if there's a better way that we can actually assist you and get through these, because you know 2 hours at this rate, okay, how much more there's going to be done, okay? And so...
Yes, Your Honor.
And remember,
we will.
you all told me, do you remember what you all told me the other week? At most an hour or two total. Do you remember that representation to the court? Remember that? We can play it back for you
I
all.
believe Real Water said that, Your Honor. and I
I'm
apologize.
not saying,
I'll come clean. I didn't anticipate it would take this long.
It wasn't just you. I asked everybody, because that's why we allocated you the afternoon. Because I doubled what you all told me. Figured that, okay, you're attorneys. You're going to tell me one thing and I'll, double it. But, folks, the doubling hasn't even gotten us through one.
It is not.
So I'm not trying to, I appreciate you all spent your time, but remember, you got to tee it up for the court to actually rule on things. So let's get through this one, then we're going to take a break so that you all can try and figure out a good game plan to get this taken care of. And maybe it's just this one deposition, and this is just the more difficult one to get through, and maybe the rest are just smooth sailing. I have rosy-colored glasses, even though they did break over the holidays. Go ahead, please.
Your Honor, that's the production manager. He's testifying about what his superiors told him, what the policies and procedures were. It's not hearsay. It's
Why? Why is it not hearsay?
Because we're not offering this, he's not offering the testimony as proof of the matter asserted. It's not proof that drinking water off the line was drinking chlorine or water in a swimming pool. He's offering it to say, this is what I was told. This is my understanding. This is what I understood based on what people said to me.
But why is that not taken care of in a prior section of Mr. Bush's testimony where he was told just not to drink the water off the line? And he already given an example. Why do you have to continue this on with the swimming pool? How is that relevant to your actual claims and issues? How easily you forget the 80s we just went through, right? Right before we got to the Nestle comment and the Desante. Remember that, folks?
Your Honor, maybe we were confused. We thought you kept that out.
The only section, okay, to be clear, the couple of lines that talked about Nestle, I did take out. I left Desante in and I left the rest in. Right? The Nestle portion, because from the relevance.
Okay. So then that clarifies it.
If I am misspeaking, like I said, it's.
No, if you kept that in, Your Honor, then I think that clears up the issue.
Okay, well, during the break, we'll double check. Why don't we take a break now? Then you all can double check your notes. I'll double check with the recorder, And it's a wonderful time since it's already been plus 2 hours, and my wonderful team would love their afternoon break. Okay?
Sounds great.
Thank you.
3:25, folks. Thank you so very much. Okay, we're back on the record, councils. So did all the brilliance that you all have come up with some kind of solution? If so, the court would be glad to hear it. What's up?
So, Your Honor, I think.
That's Mr. Parker on behalf of plaintiffs. Go ahead, please.
Thank you so much. Thanks for introducing me, Your Honor. Your Honor, what I think we've come up with, by no means a perfect solution, but perhaps it puts us in a better position than we are right now, is trying to provide a better decoder ring, number one. One where you have to send off a whole lot of cereal box tops to get a really good one. And trying
Or
to
Cracker Jacks, but go ahead.
That's right, or Cracker Jacks. That was one problem between the Cracker Jacks and the Crunch and Munch. I actually like the Crunch and Munch better, but you get prizes with the Cracker Jack box. Old school stuff. But John, what we've come up with is perhaps re-policing ourselves in terms of designations as well as objections. And we'd like some time to go back through it, create a better decoder device, and provide that to the court after we reevaluate the designations and the objections to those designations. One of the things that we've learned collectively is that certainly we can do a better job of fine-tuning the objections, the particular objections that pertain to the deposition excerpts. And then, given some of the direction the court has already provided, perhaps we recognize that some of these objections and designations may not be as well taken as we thought. So that's what our plan is, Your Honor. If you could give us any other time in the future to allow us to do this and represent it so that it doesn't take as long, because we still have 19 designations to go through, depositions to go through. And it doesn't seem fair to the court to have to go through it in the way we've done it thus far.
19, huh? That's what I thought. I know.
You're correct. You see, I got two big binders here, Your Honor. I believe in paper, and it seems like the ET&T people do as well. They have their paper.
Yeah, no worries.
Mr.
Okay.
I'm the odd man out.
Well, no, Mr. Pepperman does both. He's very savvy.
Okay. The council, couple of questions. Let's walk through. First off, is that the consensus of all the parties, or is that just one party's position?
That's a consensus on behalf of Terrible Herbst, yes.
Yes, Your Honor. Joul Odou for Rojas.
Well, that part, so now we've got to figure out a solution, because you all start trial. When you start trial, and you don't want to take up your trial days and or jury selection days doing depot designations, because that would not be fair to the members of our community, right? So we need to find you some time. So let me ask a couple quick background questions so we can get where we need to go. Given the rulings, which I understand have not yet been memorialized in writing, but how much legitimate time do you anticipate the trial's going to take? Because as you know, that's kind of also been a moving target, and based on rulings and things, it may have changed, it may not have changed. So let me hear what that one is, because then my next question is going to, we're just trying to find placings and times and things like that. So,
Your Honor, we've been fine-tuning our trial time estimation, Your Honor. One thing that has developed over the weekend that's positive is we'll be circulating hopefully a stipulation at the beginning of next week on this. We're working on it now with Great Americans Council for Terrible Herbst. We have an agreement as to causation, liability and causation for Marion Brody now. So now we don't have to worry about that outlier for the real water admission.
so your Brody carve-out on causation may no longer be by the time of trial. Is that where you're?
That is
Okay.
correct.
It was just sent over to you moments ago.
I was told just sent over to me moments ago. So that's one thing that's helpful to the case. Oh, you're fine.
Yeah, it's picking me up here.
Thank you so much. We've also, depending on how we work out the 19 deposition transcripts we have, when we met Christmas Eve, I think it was Christmas Eve we met, we're thinking now that we should be able to finish our presentation by, if we start on the 16th, we believe that we'll do openings on the 19th, and we should be able to finish our case in chief by the 29th or 30th of January. So if the Gallagher case is in any way a prediction of how much time the defendants needed, because we had three defendants in that case, we would suspect that the case should be finished by December 7th or 8th is our prediction. February, I apologize.
Now
Your Honor.
remember, we
February.
are dark. Remember, we are dark. February 8th, 9th, and 12th.
Okay,
Remember that from way back when?
so it would be great if we could finish by the 7th. Worst case scenario, I would think that we'd be done by yeah, that's what I would think would be the worst case scenario, Your Honor. Somewhere you're dark, 8th, 9th, 12th. So then it may flow into that next week. But we believe we'll be done by the 29th. Your Honor. Hopefully, the defendants in the last case took 2.5 days. That was it.
Okay. Real water, your thoughts on general timeframes?
Your Honor, you said the court will be dark January 8, 9, and 12, or February?
February
Thank you, Your Honor.
8, 9, 12. Same as we said a couple months ago.
I agree with Mr. Parker. That's a good approximation.
Okay, terrible.
I would agree, Your Honor, with that estimate. We probably have about 2 to 3 days total of trial testimony from witnesses and experts. And that may be diminished further depending on who gets called in plaintiff's case in chief.
Okay. That part one of the question was because I didn't know. I'm trying to figure out your scheduling, right? Because I got 2 trials before you.
I mean, I think we can still do it starting on the 16th, Your Honor. I think we still have enough time to represent these deposition designations to you.
Okay, so the second, third. I'm looking. As you can appreciate, we set a variety of things to get taken care of before your trial started so that you'd have less interruption from multi-day evidentiary hearings in the middle of your trial and things. So I'm now trying to see about what time we have. How quickly are you going to be able, I mean, I figure we're going to finish at least the one today, Bush's today. I mean, but how quickly are you going to be able to get to the court the rest of them? I mean, that's, you know what today's date is, you know the holiday dates. I have people flying in, so they've got the 5th and the 8th. I might have some time on the 3rd or the 4th and the 29th. I mean, is it going to come back to me by tomorrow? Is that realistic? So that I can block out time for the 29th? Or is that not realistic? And so therefore, I have to look at some time possibly on the 3rd and the 4th because I can't give you the 5th and 8th because, well, it doesn't matter why, but people are flying in, they've already booked it. And
I would think the
fair's
4th is
fair.
a safer bet, Your Honor. That way we have the
When
next
are you
couple of
gonna get
days to get it done.
Yeah, because remember you have to give it to the court. Court did spend a lot of time already reviewing these, but with all the questions it had, it could only get certain far and small. Like I said, Godfrey now has that jump drive, which worked in my home computer, but didn't seem to work on this one. Let's see how busy my 4th is. Just 1 second, please. But do you think it's realistic to get through all the rest of them in part of one day?
I don't think we have much of a choice, Your Honor, so we'll do what we have to do.
Well, my pretrial conference is on the 4th. Can't move those.
If we had it in the afternoon again, maybe that would be great.
Hold on just 1 second. I'm trying to look if maybe I could start you, take a break for my pretrial conferences. You're telling me it's not realistic to book any time on Friday, right?
I wouldn't waste your time, Your Honor. On Friday, I think we'll still be trying to streamline this event for you.
They're coming in on the, see, because the 3rd's your calendar call. Which reminds you, I'm going to segue for a quick second and circle back. According to the vault says only one party has provided them the electronic exhibits as was required. One party out of 3. I'm not calling out names. That party knows who they are. Thank you. The other two parties, according to them, they have not received anything. I'm not gonna say who's the party who's done it. The party
No,
knows
no,
who's
no.
done it.
We submitted, it was a joint exhibit list with joint exhibits, so all
Is it for all, that's all the exhibits?
all the
Yes.
exhibits were submitted by
Oh,
us.
okay,
yes.
because it was represented to the vault clerk that it was plaintiffs, which is why we got the email that said it was only one. Not
It
all
wasn't
three.
my office who handled it, but we coordinated with the Terrible Herbst and Real Water, so it's all the exhibits.
All the exhibits, and it has detailed exhibit lists with who's got objections. Did you
Yes.
provide to, you don't have an exhibit list, right?
No, I can go down and get the documents from the vault.
I'm sure you all can email an exhibit list to our team, right?
Your Honor, we're having the EDCR 2.67 conference tomorrow, so we will have the detailed exhibit list with the added objections after tomorrow.
So you all did a prospective electronic exhibits, realizing that you're gonna fine tune it at your EDCR 2.67 or something similar to that?
Yes, Your
Normally,
Honor.
when they get the test done, yeah, I mean, you have it all in you. So is it all then? Because they have ranges. You have ranges, so what have you done with your ranges?
I believe plaintiffs are 1 through 2,000 or 1,000. Real Water is 2,000 to 3,000, and Terrible Herbst is somewhere after that.
So you submitted them in your range sections, is that what it is? It's just,
Yeah, we got the range sections from the court, Your Honor, and we submitted them in compliance with that, and there should be one vault or whatever they call it.
but there's no exhibit list that was provided to them, right? There was just the checking.
We've exchanged exhibit lists amongst ourselves and can certainly email to the court because nothing's going to change.
We just need to add the any stipulations or objections.
Okay,
to
I'm just, like I said, we got notification, we're following, obviously making sure, and we got a notification that only one side, and it was represented, I guess, to them, that was plaintiffs, but, okay.
I just want to correct it. It's not just plaintiffs, it's all of us.
Okay, so my wonderful clerk will email the vault that that's done, so they can take it off their checklist to follow up with us, because you can appreciate, right, that they're trying to make sure everyone gets taken care of, okay. So everyone has all of their exhibits, it's just we're waiting for an exhibit list, that's a calendar call issue, I don't need to go in today, as long as you'll have done the electronic exhibits. I need to circle back then to the depot designations, trying to find you time, you're coming, the reason why I was going there is because you're coming in for your calendar call on the 3rd, what I was trying to see is I have a special setting. No, I have an evidentiary hearing on the 3rd. I was hoping, I have to check to see how long they've requested. I do not see. We have taking a quick. I'm trying to see how much time that evidentiary hearing is stated, because what my thought was what I might be able to do is, yeah, pardon? Eyewitnesses, is that what it is? Then I got a motion to withdraw as counsel. Okay, that's gonna take more than just a minute to evaluate that. What I was hoping to do is possibly, if that one could take the morning, that could start you all like at 1:30 or something on the 3rd. Do your calendar call that afternoon, so you're not coming in twice, and just do straight calendar call and then depot designations. So what I am gonna do is I'm gonna say I'm with the carve out. I'm gonna tell you 1:30. Do you all want this? Do you want 1:30 on the 3rd? And we move your calendar call from the morning to the afternoon, and we go straight from calendar call into depot designations on the 3rd. Choice 2 is you come in the morning, and then you come back in the afternoon. But I have to do my caveat. My caveat is I need to check with that case. It's already set for 5 witnesses in evidentiary hearing to make sure that they haven't already told me that they need more than just the morning, those witnesses, okay? Because if they've told me they need it all day, I don't have access to that right now. I'd have to check with my team. That will take longer than a few moments, and it makes more sense for us to check and get back to you. So I may have to change what I'm just now saying if we've already promised the time elsewhere that I just don't.
And I would prefer the 1:30 instead of coming in the morning. On behalf of plaintiffs, Teddy Parker.
Sure. Is that consistent with it? it's not on here. Sorry, oftentimes we put the balance of time in our evidentiary hearings. I don't see this one does. I thought that might be the preferred choice, but like I said, I'm not going to take away your 8:30 calendar call if you want it.
Your Honor, Terrible Herbs would agree with plaintiffs on this.
Afternoon?
Afternoon, Your Honor.
Great.
Joul do for raw water, we agree.
Okay.
Your
So-
Honor, and if I may, in terms of the remaining designations of Mr. Bush, we would request some time to reconsider those objections and take those up so as not to waste the court's time this afternoon any further.
We have a good 45 minutes to an hour. I'd like to try and get through something. You know what I mean? Is there any of the other ones that you think we can efficiently utilize this time for that we should jump into? Or do you all think that that's not a fruitful use of time? Give me a heads up, please.
The only ones that, oh, I'm sorry.
One quick one might be Casey Aiken.
I don't, maybe, I can tell you my plan was to argue that one. So there's some case law that goes along with that one, along with some exhibits that go to that one. That may take longer than you suspect.
Okay.
The only thing that I thought would be quick would be Luis Kessler, Susan Doran, and Trey Fisher, because they're all customer complaints. And you're objecting virtually to customer complaints. So I thought that would be easy because I've already plowed that ground. I have nothing more to add to those.
Your Honor, Joul do for raw water. We think the problem is that those go directly against real water's motions 1A, 3, 9, and 10. And so while plaintiffs may think it's going to be quick, I disagree.
And does the court need an actual order on those so that we're clear the breadth and scope? Are you all going to raise a lot of issues about what's your own perception of what? I don't know if you've yet ordered a transcript or not. If you're going to quote transcript back to the court or not, I don't know. But if you're not, am I going to have an issue of you all providing your own perceptions that might then require the court to go back and double check from the transcript each party's perceptions? Not saying that you wouldn't have exactly the same perception, maybe you would, but I see that as a potential issue, unless you all have already met and conferred on that and you think that everyone's going to have the same understanding.
We do not believe we're going to have the same understanding, and so this is going to be an argument.
Okay. Any other ones you think? So that's...
All three of those are applicable to real water motions 1A, 3, 9, and 10.
So is there any other depot designations that you think that the court can take care of for you today so as to move your case forward?
No, but I want to say, Your Honor, you've already moved it forward today. We've done a lot.
We're trying. We're trying. Okay, appreciate it. But realistically, is there anything else that's going to be a fruitful use of time? If the answer is no, the answer is no. If the answer is yes, let me know. I mean, let's see what we can do to get you taken care of.
Yeah, real water does not believe so, Your Honor. We think this would probably be time would be better spent the parties working on trying to make this an easier process for the parties and for the court.
Okay. My wonderful clerk, while I was talking with you all, they had requested the special setting that's on the 3rd. Even if I go away. Other calendar call, that's going to go away. It looks like they request. If I start now. Looks like they requested 4 hours on that other case. So it looks like I'm going to tell you 2 o'clock, not 1:30 on the 3rd. Okay. So hopefully I can take that care of by 12:30. We break for lunch from 12:30 to 1:30, and then. Because I got another matter that I got to deal with. So I can work for y'all. That's going to be a conflict with. Okay. We'll tell you 2 o'clock. If it changes within the next few days, I'll let you know. But it's probably more realistic 2 o'clock. Okay. And then on the 4th, what we have for the 4th is realistically. I can start you at 11, break for lunch, or I can start you at 1 after lunch. On the 4th to go over more the depot designations.
Joanna, we would prefer the afternoon. We have a deposition in this case that morning. Excuse me, different case.
No objection, Your Honor, from the
A
plaintiff.
coordinated case or something? Okay.
Correct.
Afternoon's fine with real water.
Okay, so then we'll pop them in at 1 o'clock on the 4th too. And are all these depots, people who, are any of these just in case depots versus depots in lieu of live testimony that you're sure it's gonna be depots in lieu of live testimony? Because I know you had a couple of people you weren't sure if you were gonna be able to bring them in. My suggestion to the parties is get me, a new jump drive, right? But give me a letter in the order that you want them taken care of so that if they're your just in case ones, maybe there's a plan B for that. Versus, or maybe you want it in the order that you're intending to call them based on, the cases in chief, or if anyone's planning on wanting to do excerpts and opening, not saying it would be allowed. You all know how you're going to be prioritizing these. If you don't, I'll pick it, but
Yes, Your Honor, thank you. We'll keep that in mind.
doesn't that make more sense? I mean, the order that you want? Okay, so I think you all have told me there's nothing fruitful that the court can do for you today, anymore. So I think what you're saying is you're going to talk among yourselves, do what you need to do. It looks like we stopped on, we were starting 91 through 95, so you want just to stop where that one was, and then we come back.
Yes, sir.
Yes, Your Honor.
Plaintiffs, yes?
Yes, Your Honor.
Okay, and then in that regard, thank you for your time, have a great rest of your day. Mr. Godfrey, if I can have my jump drive back, although it might be moot because they may be giving me another one, but, that would be great, and have a great afternoon. And I
Your Honor, do
think
you have a trial date tomorrow?
trial tomorrow, yes, I do have trial tomorrow.
Do you mind if I have some of my interns come and listen in on it?
Sure, it's a bench trial, continuation of a bench trial, they're welcome to come.
And what time do you start tomorrow?
Oh, hold on 1 second. Huh? Thank you. 10:30 because I got a full calendar first thing in the morning, starting at 8:30.
Okay, I'll have them come tomorrow. Thank you so much, Your Honor.
2 o'clock on the 3rd and 1 o'clock on the 4th.
Going off the record then. Thank you so very much. Have a good one.
Thank you.
Thank you. Have a great day.